Good evening and welcome to the monthly meeting of the Arlington Board of Zoning Appeals, which is also known as the BZA. I'm Judy Freshman, Chair of the Board. The Board's made up of 5 citizens appointed by the Circuit Court. In addition to myself, we have Charles Smith, Paul Melnick, and Peter Owen. Intimalis will not be joining us tonight. Also present is a professional staff, including Arlova Vaughn, Zoning Administrator, Cliff Hogan and Blake Bowen, assistants to the zoning administrator, and Amanda Clement, acting BZA coordinator. And in addition, we have Minshao Kaur, assistant county attorney. We thank you for being here and extend a warm welcome. To avoid disruptions, we ask that you please turn your cell phones or pagers off or put them in the silent mode. On the front table, you will find copies of the staff report for each case before us this evening. I recommend that if you've not seen the staff report for your case, that you get a copy and review it before your case is called. The board's powers are prescribed in the Code of Virginia and are set out in further detail in the county zoning ordinance adopted by the county board. The Board of Zoning Appeals does not have the power to rezone property or to amend the regulations set forth in the zoning ordinance. That authority rests with the county board. The board does have the authority to do 3 things. We can approve use permits that allow modifications of placement requirements for structures on 1 and 2 family lots, where there is no option in the zoning ordinance to allow such modifications. We can grant variances from the specific requirements of the zoning ordinance, and we can decide appeals of decisions of the zoning administrator. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary in the public interest, including limiting the duration of the use permit. In order to approve a use permit, the law requires that the board find that the proposal meets conditions and that the use permit will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not be in conflict with the purposes of the master plans and land use and zoning related policies of the county. To do this, the BZA shall consider whether the modification will promote compatibility of development with the surrounding neighborhood, because the structure's overall footprint, size, and placement are similar to the structures on the properties surrounding the lot in question, and whether the modification will help preserve natural landform, historic features, and/or significant trees and foliages. When granting variances, the board must determine that the strict application of the ordinance would produce undue hardship, that the hardship is not generally shared by other properties in the same zoning district, and that the authorization of the variance will not be of substantial detriment to adjacent property, and the character of the district will not be changed by the granting of the variance. When deciding appeals of the zoning administrator, the board must determine if the administrator acted correctly. This evening, cases will be called and a brief staff report and recommendation will be given. Following that, board members will ask any questions of the staff they may have. Next, applicants or their representative will be given an opportunity to make comments to support the application or appeal. If they choose to make a comment, they must come forward to the podium so their comments can be recorded for the record. Next, all speakers for the item will be called. Speakers must fill out a speaker slip, which is available on the table in the front of the room. After we hear from speakers for and against the proposal, the board may permit the applicant a brief opportunity to clarify any points. The board may ask questions of any speakers, but does not permit and will not condone any cross-examination or direct questioning by others. We've deemed the following time limits for speakers to be sufficient. For use permits and variances, 5 minutes for applicants, 3 minutes for representatives of organizations, and 2 minutes for individuals. For appeals, 20 minutes for applicants, 3 minutes for representatives of organizations, and 2 minutes for individuals. After the board has gathered all the information they need and discussed the case, it will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. After your case of interest is heard, you're welcome to stay for the balance of the session or leave at your convenience. Again, thank you for being here this evening. Please call the first case.
Good evening.
Thank you.
The first case is V-11120-16-APP-1, an appeal by Robert Jones, the owner of a violation notice stating that the building on the subject property is an unpermitted multiple-family dwelling located in the C2 zoning district at the premises known as 5029 23rd Street South. So I have a short presentation.
Please, go ahead.
Okay. You can go. So at the subject property, there was zoning enforcement actions initiated starting back in May 2015, and site inspections conducted at that time and in December 2015. And out of those inspections, code enforcement and zoning enforcement staff observed the presence of 4 dwelling units within the building, and subsequently a violation notice was issued on December 28th, 2015. The first unit was visited in May. Unit C, actually, if you go back, we've just tried to divide up so that we could keep track of where these units are located using a lettering system. So the top right is the first unit that was visited. You can go forward now. In May 2015, at that time, after that point, our staff tried on multiple attempts to access the property by sending letters of intent to inspect and requesting what's called a courtesy letter indicating that we believe there's the presence of a zoning violation on the property. Actually, you can keep going. And so that went on for several months. As I mentioned, it started in May. In December of 2015, an inspection warrant was issued, so our staff was actually able to enter the remaining 3 units. This is the first of those that were inspected in December, the second, and then the final one. And then at that time, the subject notice of violation, which the appeal is of, was issued. You can go to the next one. So the determination that the notice of violation contains is that the building is a multiple family dwelling due to the presence of 4 separate dwelling units. Multiple family dwellings are defined as having 3 or more dwelling units. And the subject property, which is located in the C2 zoning district, that district doesn't permit multiple family dwellings. The property, you can go to the next slide. The dwelling was constructed in 1955, and at that time, the property was actually located in the city of Alexandria. It transferred to Arlington County in 1965. So in our records from 1965 to the present, we found several instances of certificates of occupancy issued for commercial uses, ranging from a upholstery store to a sewing shop. The most recent issued in 2003 for a convenience store / deli on the lower level. We found no such record of either building permits or certificates of occupancy to change these uses to additional residential uses. And as a change of use requires a certificate of occupancy, there was no record found showing how these units were created legally after some sort of county review. Next slide. The appellant speaks to a change in the zoning ordinance that occurred and argues that because multiple family dwellings were once permitted in the C2 district, that this use has been grandfathered. The zoning ordinance did change in November 2003 to eliminate multiple family dwellings as a permitted use in the C2. However, we found no record of that being legally established before that time, or that it was maintained continuously since then. As I mentioned, the last certificate of occupancy was issued in 2003 for commercial use in the lower level. the current owner took possession of the property in 2005 after the zoning ordinance had changed. And at that time, multifamily dwellings were not permitted in this district. So just to sum, last slide. The current use is not permitted in the C2 zone. We came to that conclusion based on observations we've made at the property, and staff feels that the notice of violation that's the subject of this appeal was properly issued.
Thank you. Questions for staff?
I have some questions, Madam Chairman.
Mr. Owen.
Thank you. Can you help me understand with precision exactly what the scope of this appeal is, not with respect to the arguments about the warrant, but just what is the ruling of the zoning administrator exactly that we are opining on today?
That this building is a multiple family dwelling, and that multiple family dwellings are not permitted in the C2 zoning district.
So there's the factual determination that this is a multifamily dwelling and a conclusion of interpretation of the zoning ordinance that that's not permitted. Those findings were made by the zoning administrator, and sorry to speak about you in the third person, but those findings were made by the zoning administrator in the form of a notice of violation, right?
Yes.
Okay. So my question relates to the fact that in some of the materials, I'm sorry I don't have it, I can turn to the page in a minute, but one of the issues was whether or not there was a valid certificate of occupancy. As certificate of occupancy cannot be validly issued for a use that's not permitted, but one of the criteria that's listed in the section says that if there's a change of ownership, except for certain kinds of residential dwellings, that a new certificate of occupancy is required. So assuming that one of the arguments that's being made by the appellant is that this has always been a multifamily, a 4-unit
Right.
Structure. And so my question is, assuming that's true, wouldn't it also be legally required for there to be a new certificate of occupancy at the time that the ownership changed in April of 2005?
Yes.
But my question is, if that were a separate reason for issuing a notice of violation, is that within the scope of what we're being asked to rule on? So my question is, what's your view as a matter of law? And I'll, of course, welcome the applicant's attorney to weigh in on this as well. But if that were reason enough to say there's no valid certificate of occupancy, would that be a basis for upholding, even though it's not the determination of fact or the determination of law that you were just outlining?
I think it would. We do talk about the change of use in the notice of violation. I think we just summarize it as a practical matter that at the end of the day, we see the violation as the fact that this is an unpermitted use in the district. But if you look at the actual NOV, we go through all the sections that could have been violated, and change of use without zoning administrator approval is one of the sections that was cited.
So, okay, I think that answers my question, which was basically, if we rule against you on the question of fact and say this inherently that this was, we agree with the applicant that this has always been used as a multifamily dwelling, we might still agree with you in terms of the validity of the notice of violation on this other ground that you didn't use because there was a disagreement about the facts. So, all right, I know that was a new twist, so if you think about more by the end of the hearing, I'd be interested to know about that. So then another question I have is, if it is apparently undisputed that there have been 2 units in this building on the top floor for a long period of time, and I wasn't clear what we call that under the zoning ordinance.
I don't know that when you say it's been undisputed.
You don't dispute that units C and D have been in continuous use as residences since at least 2001?
Oh,
That's not conceded?
Yeah.
All right. Well, if it were true that units A and B were relatively new, but C and D have been there for a long time. I'm still a little unclear about what category a building is in if it has two dwellings, but they're not over-under, they're side by side.
That's the
what is
duplex
that?
versus semi-detached, which I can never remember which is which.
Duplex seems to say it has to be over-under. And then I think there was a reason why, what's the other one that you just said?
Semi-detached.
Detached. There was a reason why I didn't think semi-detached would apply either. Yeah, so semi-detached requires a lot line separating the units. So here there was neither a lot line separating the units, nor were the units vertically over and under each other. And so to me, that seems like a little bit of a no man's land in terms of what category such a dwelling would be in.
We have some record of the upper floor being used as residential. I don't think we have records of two units, two separate units with separate living, cooking, bathroom facilities on the upper floor. That's what you're referring to.
So essentially what I'm asking is, in 2004, or at any point prior, would you have issued a certificate of occupancy for two dwelling units on the same lot that are not over and under each other?
I would have to go back and look and see what the permitted uses were at the time. I can't recall if one family versus two family versus multifamily were all permitted in the same way.
Right.
Or
and to make the question perhaps a little bit easier, what if today someone were to construct, or ask permission to construct and occupy a unit, a structure in that configuration, 2 units, no lot line separation, side by side, not over top of each other? Would you issue a C of O for that today?
so for today, the permitted uses, the residential permitted uses in C2 are one family detached. So I could not.
Okay, so even the 2 units would not be permitted under the ordinance as amended in 2003, but might possibly have been
Possibly.
prior to 2003. Okay. And then my final question is on the nature of, did I misspeak? No. Okay. So the final question is, the definition of use includes not just actual occupation of a structure for the purpose of the use, but configuration of the structure for the purpose of the use. So one possible interpretation of the appellant's claims is, as I understand, and the appellant can correct me if I'm wrong, but my understanding is one possible interpretation is that some of these units, when he purchased the property, were built out for residential use, but were not being used for residential use at the time. So it seems to me that a vacant apartment is still in, for purposes of the zoning ordinance, is still in use as that term is defined in the ordinance. And then the question is, what if the use is, and here I guess what it boils down to is, since they were storing a bunch of equipment in it for the, again, according to my understanding of the appellant's position, that they were storing a bunch of equipment in it, and so that was not, that may have interfered with the ability to rent it out as an apartment. And so I guess I'm wondering, do you have any, have you issued any guidance, or do you have any interpretation that you've issued in the past about what the boundary line is for something being configured as ready for the use versus actually being used? So as an example that's not from this particular case, but what if I had an apartment and I had ripped out the doors and windows, right? But otherwise the apartment's all ready for rental, but it doesn't have any doors or windows. if an apartment is in that configuration, would you say for purposes of the zoning ordinance interpretation that it was at that moment in use as a residential dwelling because it couldn't in practice be used that way? Because it was missing some important features of like doors and windows? Does that make the use discontinuous even though it's configured the right way?
I think if we looked at how, I mean, I guess to go back to the definition, arranged, designed, or intended. And so if the space was arranged in a manner that's consistent with residential use, I think we'd arrive at the same conclusion.
Okay. So that's another one. If you think you have more to say later, I'd be interested.
I guess the only thing I would add, it's related, is that part of the certificate of occupancy process requires an inspection. And so at that time, our enforcement staff go out to look at a space and determine if the arrangement of whatever that space is consistent with the use that they said they were going to initiate or try to establish. So we're often in situations where, you said you were opening a retail store, but there's nothing to sell here. There's no, you know what I mean? So it's a judgment call based on what they see and how the space is fitted out and arranged. If it's supposed to be residential, but there's nowhere for people to bathe or sleep or eat and cook, then it wouldn't pass. I don't know if that helps.
Yes, that actually does exactly answer my question. Thank you. Thank you, Madam Chairman.
Any other questions of staff before we hear from the appellant? Mr. Lawson?
Madam Chairman, members of the BZA, my name is William B. Lawson, Jr., and I represent the applicant. I want to go up, make some comments and share with you all some things I'd like for you to keep in mind as you consider this. First of all alleged activities happened before Bobby Jones became the owner. So, the county's saying, well, you did this and you did that. Whatever happened was done prior to him becoming the owner. He didn't do any of these alleged things. You all have my memo, I suspect. Okay. For the reasons set forth in my memo, we believe that this was an improper search. We have consulted with a civil rights attorney, and that attorney tells us that he thinks this is a clear-cut violation. However, he was unable to share with us what he thought the damages would be. He said it could be $20 to $20,000. So anyhow, we have not pursued that. This is about the fifth case like this. Arlington County does all this work to encourage affordable housing. We have the, something wrong? Oh, okay. Arlington has done the affordable housing plan and so forth. And yet in a situation like this, the full might and weight of the Arlington government is brought against this gentleman to crush the ability to provide the very affordable housing that is claimed is so desperately needed here in Arlington. I want to reemphasize that at the time, RA 818 was a by right use in C2. And so having a multifamily structure in C2 was a by right use. I want to point out that we had offered a compromise to the county that was rejected. What we offered was, let us have the 2 units upstairs and we will convert the basement to commercial. The county said no to that, even though they're hanging their hat and they're hanging their case on the fact that commercial COs were obtained for the basement. Every commercial CO is for the lower level. And I would respectfully submit that if in fact Abe had implemented the deli, that's a situation that would have existed. Just as an interesting exercise, I checked to see if we all have certificates of occupancy for our homes. I don't have one for mine, and 3 of the BZA members that live in homes, you don't have one for yours either. So for whatever it's worth, I just wanted to share that. The county acts like, well, you can't produce a CO, that's the end all. never happened, never was a CO issue. We don't know that, and the county has not been really good at keeping records through the years. One of the things that the staff report states is that to be a grandfathered use, we have to show that it was residential prior to 2003. So to be grandfathered, we have to show it was residential prior to 2003. We submit that we have done that. Before Mr. Jones owned it, it was owned by Abe BZA. And his wife is still living. She let him do the business, but she said that this has always been used residentially to her knowledge since Abe bought it, and he did not open the deli because he couldn't get a liquor license, is what she told us. Finally, and most importantly, in putting aside all of this, I don't see how we violate the zoning ordinance. Now, we may have violated the former zoning ordinance, but we don't violate the new zoning ordinance. In the staff report, it says, the zoning ordinance defines dwelling units, plural, as, quote, a building or portion thereof designated exclusively for residential occupancy. The definition of a dwelling unit is a building or portion thereof designed exclusively for residential occupancy, including one family detached, detached duplex, townhouse, multiple family building. So I think that under that definition, we're one unit. And under the old definition, you had to have separate kitchens, and you had to have no ability to get from one unit to the other without going outside. That was the old zoning ordinance. That's no longer the definition. The definition has been changed. Again, just like the appeal you recently heard over grandfathered lots, the zoning office is confusing the old ordinance and the new ordinance. And I have both the new and the old ordinance, which I'll hand out to you. To address a couple of questions, Mr. Owen, you're as detail-oriented here as you were on Transportation Commission. To answer those questions, throughout my career, when you change ownership and you don't pull a CO, you just go pull the CO when it comes to light. And in this case, we can't go pull a CO because C2 no longer allows RA 818. So, in the past, had that come to light, when it was still allowed as a by right use, a CO could have been pulled. Again, as far as failing to pull a CO based on change of ownership doesn't extinguish the use. What's important is, has the use continued without interruption for more than 2 years? Happy to answer any questions. Mr. Jones would like to share with you the human impact of what happened when the zoning office threw these people out of their homes over the Christmas holiday.
Hi, my name is Bobby Jones. I own a property at 5029 South 23rd Street. When I bought this property in 2005, I bought it from Abe through my attorney, Earl Schaefer. It was rented as an apartment building. There were beds in every unit. Now, Mr. Green paints this picture that, the modifications done on the outside, and I don't believe he thinks I did any of the modifications on the outside. But he conveniently makes the argument that somehow I converted the inside to exactly match the outside, but that's not the case. Make it perfectly clear I made no modification to the structure whatsoever. I bought it as is. It is in the real estate listings through the years as a 4-unit apartment building, and we've got the documentation to prove it. Now, when I got the property, Earl Schaefer told me that the reason that Abe got out of it because he wanted to have a deli with ABC, but he couldn't get ABC because it was too close to Wakefield High School, so he dropped the whole project. He never occupied it. He never went through with commercial deli. There was a bunch of equipment, large, very large Vulcan gas grill stored in the lower right unit. It wasn't connected. It couldn't have been approved. There wasn't any hoods or gas hoods. It was gigantic stuff. But there was a bed in there. There was a bed in every unit. So I said, okay, I'm just going to rent this out as affordable housing. Those units rented for $800 a piece, including utilities, parking, laundry, everything, okay? And I rented that out continuously until May of 15, when one of the tenants, allowed him to move in there, but he moved another person in there, his buddy, his girlfriend, and 3 other people. It's a 500-square-foot place. And I said, that's too much. And he kept putting octopus plugs in the kitchen and blowing the breakers. And because he got too many people in there, and then I said, look, you got to stop this. I'd unplug everything. And then he finally went and hired an electrician to put a bigger breaker in. I said, that's it. You got to go. You're out. Can't help you anymore. Well, he got mad, took a hammer to the place, destroyed it, and called the county, and that's how we got into this place. I got a call from the zoning office about May of 15 on this thing, and I told them what the deal was. And the call I got was, we can fix this right now. Just go fix the outlet. And I said, okay, and I did. And I didn't hear any more from this thing until 2 days before Christmas. 2 days before Christmas on 15, I got a scene out of Les Miserables. I got Inspector Javot coming in there with kicking doors in with an illegal search warrant. He kicked handicapped people out in the snow 2 days before Christmas. Now, I don't know why he thinks that the snow out in the snow is safer than being in a nice warm apartments. They've been there for years. But he kicked them out. Handicapped people kicked them out in the snow. And I thought that was outrageous. The one fellow that got kicked out, Stephen Smith, he bummed around on the county streets for 7 months until I found a place for him that he could afford in July. This past July, I finally got him a place. His mother cried when I got him a place to live finally, a decent place to live. Now, Arlington County, they say that, if I want to do this, it can be a deli. And I would ask you to look into it, connect, make a synchronization, put down your rule books, put down your zoning books, and make a synchronization between your heart and your head. And ask, which one does Arlington County, wherein lies the need? Do you really think they need another sandwich shop, or do we need more affordable housing? I got 4 units sitting empty. They've been 4 continuously used affordable housing units. They're sitting empty now. The county has a dire need for it. I can provide affordable units for $800, 1-bedroom spaces, includes all utilities, parking, laundry, everything, decent place to live in the county. The county can't do that. I can do that. Now, my friend Danny Troutman builds all these big fancy houses in Country Club Hills and on Ridge Road, and if you go into these $1 million, $2 million houses, they've got you could cook a breakfast at the bar in the master bedroom. They've got a movie theater in the basement you cook a 9-course meal on. They've got butler pantries. They've got wine cellars. They've got all this, and nobody says anything about that. But if you try to take a hot plate and a microwave and provide it for a low-income person, you got Inspector Javot down on you. And, that's not right. You've got a front edge of young people who cannot afford Arlington. That's the first wave that's coming. The second wave that's coming are your parents. It costs $4,300 to put an elderly person in a memory care unit. And none of these groups can afford this. So people are seeking their own solutions. The state of New Mexico, they created an experimental housing zone and turned the entrepreneurs loose to create affordable housing. I've got affordable housing here now today. It's been in continuous use. I didn't build these units. I didn't modify on the outside of it. I certainly don't believe that Mr. Green thinks I modified on the outside of this building. He's making a non-statement of fact when he thinks that I converted the interior of the building. I didn't. It is what it is. It is what it has been. It was going to be a deli. It's not. And I'm asking you to give me a small crack here in the opening and let this thing go forward in some fashion as an affordable housing unit, which you desperately need. I don't know how many people went to Starbucks this morning to buy your cup of coffee and took in consideration the income disparity of your salary versus that barista's salary. But 2 baristas can just about afford an $800 unit. They can't afford $2,000 and $3,000 a month apartments. There's a scarcity of these kinds of things. This is in a commercial zone. None of the neighbors were complaining about it. C2 use has always, I never questioned it when I bought it because C2 use always supported apartment buildings. I just took it for granted. There's apartments there. It's a use for it. I had no idea you changed the zoning. So I'm asking you to think about the macro picture, what's needed. It's going to take some leadership. But, these technological and the ever-escalating rents are coming at you, and they're coming at you at warp speed. So, you got Airbnb. People are seeking that as a solution. You've got these senior homes that people can't afford. This is a solution right here today. I got 4 units sitting empty, and I'm asking you to give me in some fashion to this go forward. You know, we got in a big argument back in 2006 about living units, what living space was. A living space was because it had a kitchen. Okay, well, we went to court over that then, and then he took that out of the regulation. So now you have no way of saying what a living space is legally defined as. Since you took the kitchen part out, how do you know I've got 4 living spaces in here? What's the definition legally of a living space? It used to be kitchen. It's not anymore. So you have no means of saying that. Any way you want to do it, you give me 4 offices and let people rent 4 offices. Give me some crack. Give me some kind of opening here. The county needs it. I've got the solution to the problem. You don't. You know, you want to destroy the good in the search of the perfect. You're destroying the good in the search of nothing. You have nothing else to offer. People are on the street. Thank you.
Questions for Mr. Jones or Mr. Lawson? Mr. Owen.
Yeah, Mr. Jones, when you purchased the property, in the contract that you offered to purchase the property or in the closing documents, was there an explicit treatment about how the tenants would be transferred over, that the leases would transfer?
It was up to me. I could continue them. I did. And, you know, they were in there so long that it was month to month at that point. So I just let it go. I just kept collecting the checks, and as people rotated out, it was such a bargain. I never really had to advertise anything. People just said, hey, this is a great place. I work at the Pentagon. I'm a security guard, or I'm some kind of service personnel, and they would find a new tenant for me and just kept rotating people in and out of their units.
Do you have copies of any of the leases that were?
I do.
If you have them with you, it might be helpful for us to see them.
I'm sorry, wasn't prepared for that. I can, you know, if you want to continue this, so I'll get more information for you. I just came here to make my case. It's a continuous use. You know, if it doesn't like exactly the configuration, want to make some sort of modification, I'm perfectly willing to do that. Just give me 2 units on top. If the bottom was commercial, that's what you want. I don't know why the county needs another sandwich shop. I think you really need affordable housing. And people desperately. I mean, it's right across the street from Northern Virginia Community College. You know, students could walk there. I've got service personnel, your baristas, your painters, your landscape personnel. These people, everybody. You know, if you don't get anything out of what I'm telling you tonight, just everybody has got to eat. Everybody and everything needs to eat, and everybody needs a place to live. This is a place for people to live.
Hey, Bob, Mr. Owen, the gentleman who did the settlement is Earl Schaefer, who passed about a year ago. Courtney McCarthy was his associate. She's in my building. We could try to find the settlement file. I don't know if it's still in existence or not, but we could certainly look for it.
Well, I mean, at this point, I don't know whether or not there's any further opportunity, but, you know, since one of your principal claims is that there was not a discontinuation of the residential use for all 4 units, it would have been helpful perhaps to have seen some of the, you know, core documentation that would demonstrate that.
Let me come back to the mic so I can be recorded. We asked Sarah, Abe's wife, Sarah, and she said, you know, Barnes, I never really went in there. I don't know if it was 4 units, but she did say that it was used residentially. But that's the best of her recollection. And she's Abe's widow. He passed about 4 years ago.
Thank you.
Any further questions? Thank you. Do we have speakers? Thank you. Other comments? Discussion?
Madam Chair, I guess I'd like to hear from staff. And it's maybe a follow-up on what Mr. Owen asked about when he was asking about the side-by-side possibility. What could, if anything, Mr. Jones do to qualify, to get COs for 4 units in that building?
Today, the use just isn't permitted, so it wouldn't be allowed.
So what could he do?
Could it be rezoned?
Rezone?
Exactly. Or change the text to allow more uses to be permitted in the C2 district.
But you're saying in 2003 that use was eliminated
November 2003.
before this property changed hands,
Yes.
but the rezoning would be an option.
Either a change to the text of the zoning ordinance or a change to the zoning map to.
Other questions?
No.
Comments? Mr. Owen?
Yes, so your contention is that multiple family units, multiple family dwellings are not permitted in C2.
Yes.
But some residential uses are permitted in C2. And if you wouldn't mind just reiterating what you're saying that those are.
Actually, it's only, for household living, we have categories now. So in the residential use category, for household living, one family detached is the only permitted use. The other uses in the residential use category are things like dormitories, group homes, and fraternity houses, but those require a use permit. So the only permitted by right residential use is a single-family detached.
And the term family is defined in the current zoning ordinance.
Yes.
Mr. Melnick?
Okay, so there's been a lot of talk about, what happened before 2003 when the ordinance changed, and what the status was at that time. However, if the top two units, were used, and then subsequently, this is before 2003, the bottom two units were also used as, living spaces, 4 living spaces. It's my understanding that an occupancy permit would have to be used for that change. Isn't that true? So, because it seems like it's that if it was that, even if the 2 top units were used as dwelling units, and then in 2003 when the statute changed, if they all were, the way I was reading the staff or the county's position is that that's all it would take, is for it to be used, all 4 units. Is that correct?
So just to be clear, the staff has not found any documentation that shows the top level had 2 separate dwelling units. The only building permit information we found was for when it was originally constructed, which had 1 level with 3 bedrooms, a bathroom, a kitchen, and a living area, and just a basement that hadn't been, it was just concrete slab. So the only building permit data we have on file shows a single-family residence with a basement. When that may have been converted into 2 units, we have nothing demonstrating when that was done, if they got permits approved to do that work. So it's hard for me to move forward with talking about the 2 units upstairs, because as far as we're concerned, we have nothing on paper that shows that that space was ever legally converted into 2 dwelling units.
But if they showed that there were 4 in fact units, before 2003 when the statute changed, would that be sufficient regardless of whether they could show an occupancy
Yes.
permit?
So again, if you start out with 1 house with just a big open space and some bedrooms, and then we could find evidence of building permits that had been applied for and approved by zoning that showed that space then being divided into multiple units, and all of that activity occurred prior to the ordinance change, then that would be sufficient. But we couldn't find any evidence of the work that was done, having the benefit of county review or approval for the actual construction or certificates of occupancy.
But that would then be that would answer, it seems to me, Mr. Smith's question, which is what options does the appellant have to cure this problem? He could apply for a C of O and provide evidence of continuous nonconforming use since prior to the 2003 ordinance change.
So I guess at this point, We've already had those conversations with the owner. I mean, that's what happens when the original violation processes took place. So after the violation notice was sent, his attorney came in and we had those type of conversations to demonstrate, show us that it was established legally prior to 2003, and then we won't have any problems. So I guess if you mean what can happen now, we've already asked that question and we didn't get that information. So at this point,
Madam Chairman, just to
Mr. Smith.
some of this time, the early part, this was not in Arlington. It was in Alexandria.
Correct.
So there may have been construction conducted in that inside to change it from a one-family home to 2 units while it was under the jurisdiction of Alexandria. And they may have those records, or...
we asked for them. That's how we got the original permit drawings. So we asked for whatever records the city of Alexandria had, and the only records that we got back were for the original permit. But yes, that's possible, and they just weren't maintained or they were lost.
It seems to me that through all of this process, if documentation existed for the creation of from 1 to 2 and from 2 to 4, or some variation in between, that it would have surfaced, and the appellant would be showing us this as proof that this is all much ado about nothing, and that's yet to happen. So I think we have to go with what we have, and particularly the fact that the use was no longer permitted before he took possession of the property.
Well, and I guess, Madam Chairman, I wonder if there is evidence that Mr. Jones has of tenants paying rent prior to 2003 and since, or after, prior to, and that would, if not a lease, some evidence. Well, he says utilities are all covered, so, but I guess following up on what you just said, if that did exist, it probably should have been proffered by now.
I would think so, because the whole point is to try to overturn this decision with whatever documentation can be shown, and we don't have it, as I see it, as I interpret all this information. Other comments and questions?
I think Mr. Lawson was trying to get your attention.
Certainly.
We did find a listing from 2001 that said 4-unit apartment building.
You mean you mean for sale?
Yes.
It was in our packet. There was a MLS listing, but your basis for saying that it was a 2001 listing was a copyright 2001 on the photo. Is there any more evidence that that was?
Also based on the picture.
That's what I'm saying.
Yeah.
Is there anything besides the copyright notice on the picture?
We think that was when Abe bought it. We don't know that for sure, but we went back over and found that listing for 2001.
I guess, Mr. Lawson, I guess to clarify my question, you're asserting that that listing was in 2001, but on the written materials that we received, the only time the number 2001 appears, as far as I could see, is in a copyright notice on the photo. And so do you have any reason to assert that listing is from 2001 other than the copyright notice on the photo?
Prove that, but we believe it was.
Okay.
See, the problem with making us prove this is the people are dead. I mean, we can't go to dead people and say, all right, what did you do back 30 years ago, 40 years ago, 50 years ago? And the assumption here is that the county's records are infallible. And our position is, well, maybe they aren't infallible. When he bought it, it was 4 units. And somehow it became 4 units. And how do we know that it wasn't done properly in Alexandria or even properly done in Arlington? We just don't know that. We can't prove it.
Okay.
Can I make a comment as to the listing
Yes.
information? As I see it here, it says there are 4 one-bedroom units, and we don't have a problem with a single-family house having 4 bedrooms. The problem here is that we consider them 4 separate dwelling units because they have separate living area, separate kitchen, separate bathrooms, separate entrances that are locked. And you don't do that. You don't have a single family living with 4 separate dwelling units. It's fine if it's a one dwelling unit with 4 bedrooms. We don't have a problem with that. But I don't think this shows that it was continuously used as a multiple dwelling unit. It just says that it's a house with 4 bedrooms.
Okay, moving on.
I actually think there may be a different, I think we might, I'm not sure I'll skip that point. I'd like to move on to the Fourth Amendment claims, Madam Chairman, if you think that's appropriate. So the appellant has argued that the warrant was not validly issued, that we should find that the warrant was not validly issued and that we should apply the exclusionary rule to any evidence that derives from the invalidly issued warrant. I'm not sure that the BZA is legally competent to rule on the validity of the warrant. Maybe we are, maybe we're not. I don't know, however, that in Virginia or based on any of the material that's been presented to us, I don't know that in Virginia or in the United States that the exclusionary rule has been applied to civil proceedings such as this. I think there's an argument in favor of applying the exclusionary rule, which is that based on the cases that we did get, which is that basically the government's hands are, assuming that the warrant was invalid, which I am for the moment assuming, that the government's hands are dirty, and if the purpose of getting the warrant was to do this kind of thing, then it's fair to apply the exclusionary rule, and that the civil-criminal distinction is sometimes used like in a divorce case, where the government might never have known that the evidence was going to be used in this other way. But here, that's not that kind of situation. However, this is a situation in which, unlike the criminal context, where money damages, Mr. Lawson mentioned suing the county, right? That they might be able to raise a constitutional claim and sue for whatever monetary damages. And so, to me, the need for using the exclusionary rule in a case like this is lower. So I'm personally not, and then also muddying the waters further in case this gets litigated beyond us, I'll just note an issue that I'll put out there, which is that I'm not convinced that there isn't sufficient evidence, even excluding the evidence that came after the warrant, to make this finding. That is, I think there may have been sufficient evidence exterior to what was found during the warrant finding. That is, they had a statement by one of the residents, they had the multiple trash cans, they had the multiple doorways, and so I think on the electrical configuration, I think that there may well be sufficient evidence for this finding, even if you do exclude all this stuff. So the bottom line is, I'm not personally inclined, as one individual member of the BZA, to apply the exclusionary rule in this case. The good news is that if we're wrong about that, the circuit court will consider it de novo as a matter of law, so the stakes are low for whether we get that part right or not. So I just wanted to address it, since obviously, in case it is appealed beyond us, certainly they haven't waived any Fourth Amendment claims because they brought them to us. So done and done.
Thank you. Any other comments?
Well, Madam Chair, just kind of to follow up just a little bit on the Fourth Amendment or the exclusionary rule issue, and I guess maybe I want to ask my fellow BZA member, Mr. Owen, given that the applicant agreed to allow inspections in May, wouldn't there be a waiver of any, even if there was a forced inspection later on in December?
Maybe. I didn't go there because I already had a couple of other reasons not to examine that issue.
Okay. Maybe it's good enough for me, though. And then, just going one more step, I'm looking at what the owner signed, and says, or private home. There's a box for apartment. And then the box next to it says, or private home. And I presume the owner or the owners, oh, maybe that was, no, I'm sorry, let me withdraw all of that. That was a tenant who allowed, but that would have just been, but there wasn't any separate designation for that tenant's address. There wasn't like a 5029A, B, C, or D, as the zoning administrator labeled them, or unit 1, 2, 3, or 4, anything like that. Okay, I withdraw that.
The mail delivered to these residents.
You're talking about,
Yeah, how was the,
Box or 4
was there
boxes?
one mailbox where everyone got all their mail together? Or were there 4? Does it go to the door? Was there an exterior mailbox, an interior mailbox?
Mr. Jones? Mail. Do you have 4 mailboxes? 1 box?
And during these inspections, did the inspectors check the, the stoves and some of the equipment? It might be possible to check the date of manufacture for those stoves to see what year they were. Are they 20-year-old stoves, or are they 10-year-old stoves? That might suggest their date of installation. Do you have any information about the date of those equipments were purchased?
I do not.
They might not have been new when acquired. I don't think it tells you.
They might not have. But I think that might have been probative evidence that we don't have, that would have been possible to the county to obtain.
Okay. You ready to make a decision? Any other comments, questions?
I guess for me, it's clear that there should have been a new C of O issued upon the change of ownership. And whether or not that C of O would have come, I think, is less clear to me, but it was not sought. And so I'm at least on the basis that the change of ownership should have generated a new C of O, I'm prepared to uphold the zoning administrator's ruling.
To a motion?
Oh, I'm curious to know what my colleagues think before I risk a motion.
Well, Madam Chair, just to reply to to Owen's solicitation of opinions and views, I would have liked more evidence of continuous use. I would like some evidence of continuous use prior to 2003 as 4 dwelling units. That isn't before me. As much as I would like, I really can't find that it has been in use, and there isn't a C of O saying that.
I would agree. I would also just mention, because we have only 4 members here, that's my understanding from the expert to my left, that we do need 3 votes. 3. We need 3. Whereas in other cases, we might only need fewer. Mr. Melnick.
Yeah, so I'd just like to say that I'm in agreement with my colleagues, Mr. Smith, Mr. Owen. I think there's lacking facts about the continuous use prior to the change of the ordinance in 2003. So I'm prepared to vote.
Madam Chairman, I'll make a motion.
Mr. Owen.
I'm not necessarily prepared to uphold the findings of the zoning administrator or to make the findings in the resolution. So let me flip to the resolution.
Well, you're either affirming or reversing.
It's just the only finding is the valid and correctness of the zoning. Okay, I am prepared to do that. The BZA is empowered to make factual findings. We can take evidence and make factual findings, which the circuit court would have to defer to. But our findings of law are de novo. So, but if we don't make any factual findings, we can still affirm. So I'll move the resolution as presented on page 6 of the staff report. So in case V1120-16-APP-1, I move the staff resolution to affirm the action of the zoning administrator in issuing the violation notice, period, without the remaining clause. So it says, because multifamily residential use is prohibited in the C2 zoning district, I would strike that. So I would just say the BZA hereby affirms the action of the zoning administrator in issuing the violation notice, period.
Is there a second?
I'll second.
All those in favor?
Aye.
Aye.
Aye. Madam Chair, I think we have to individually signify our votes with a
Okay, new to me.
aye.
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 Thank you. Thank you.
Yeah.
Next case, please.
V-110-9-0-15-VA-4, a variance request by John Argyropoulos, owner, to permit a total lot coverage of 55.9% instead of 37% as permitted, regarding a new driveway expansion in the front yard. The property is located in the R10 zoning district at the premises known as 4741 Rock Spring Road.
Questions for staff? Mr. Owen.
Thank you, Madam Chair. So at the May BZA hearing, the applicant presented a doctor's note, possibly establishing the disability. The doctor's note came to us after we had received arguments from staff about the lack of demonstration of the disability. And I'm wondering if you have any further comments now that the doctor's note has been presented about whether or not a disability has been established and how that might relate to your recommendation.
So we did, I believe, at the May hearing, is it May or June? I can't remember. Okay. Okay. We did accept the statement for the doctor as a demonstration of the disability. I think what has not changed is the taking that into consideration with the request and the standards that are pointed out that have to be met in order to determine that this is a reasonable accommodation. Our position has not changed regarding whether or not the accommodation is reasonable and necessary. So yes, we do accept that a disability has been demonstrated, but there wasn't any additional information or analysis or new arguments provided that spoke to the second part of that. And so that's why the report didn't substantially change.
Thank you.
Sure.
Other questions? We hear from the applicant, please.
Good evening. I'm Keith Martin, and Ms. Freshman, Mr. Melnick, it's been 30 years. Good to see you again. This variance is to allow 55.9 coverage. It increases for a proposed driveway. The applicant is a veteran and is battling stage 4 cancer. His mobility is deteriorating and to a point where it has become increasingly difficult and soon impossible to reach the living level from the basement driveway entrance. He also found it difficult and dangerous to back his car out of the driveway onto Rock Spring Road at this location. I too found it difficult sometimes backing out after playing golf at Washington Golf right across from the driveway and almost being T-boned. He is proposing a short driveway on the left side of the lot to take him to the front corner of his house. The existing window will be converted to a door to the first level. There will be a 2-foot rise to the door from the driveway, and a ramp or lift will ultimately need to be installed. That has not yet been designed. The last time you reviewed this, a full circular driveway was proposed with greater coverage. I convinced Mr. Argelopoulos that if his two goals were, one, access to the first level, and two, ability to drive forward on a Rock Spring Road, this could be accomplished with the current design. The design also provides no impact on lots 1 and 3, as the new driveway will be an average of 12 to 14 feet from lot 1 tree line along the property line, and no change to the shared driveway with lot 3, where there would be stormwater runoff. The applicant and neighborhood is anxious to put this front yard back in presentable condition. I submit this variance request is not a special privilege, but a medical necessity with little or no impact on abutting lots. Ladies and gentlemen, you know, I've been doing this 35 years, and it shook me the day I got the phone call from this gentleman saying, I need your help. I think I'm dying, but I want to fight. And his daughter just graduated from law school, William and Mary, and I heard her in the background crying. And I went to my partners and I said, I've never had a phone call like this, but I want to do this. And then when I read the staff report, and I didn't ask for the legal opinion from this other law firm, and I mean, my eyes glazed over, you know, what the Sixth Circuit thinks about ADA requirements. My first thought was, what happened to compassion? You know, what happened to basic human compassion? And so I convinced John that if your two goals were to get to the first level and not back out on, we can accomplish this with half the design. And I'd heard he was a hardhead from his neighbors. And he fought me. But he agreed. He said, you know what? I said, let's not be disingenuous here. Those are your two goals. These can be accomplished with half the design with no impact. And so I'm not asking for hardship. I'm asking for compassion. I'll be happy to answer any questions.
Questions for Mr. Martin? Mr. Melnick.
Good evening. Good to hear from you tonight. I brought it up in past hearings on this particular case, and I have a letter from a neighbor, and it's someone who's in opposition to this. But my question would be, I did hear there's an elevator in the house, and it would seem to me, and I don't have an elevator in my house, but that the cost that's going into this, the driveway and everything else, why not use all that, the money that this would take for the repair of the elevator or refurbishing it? Because that's been my thing, is if this has an elevator, why not repair the elevator and use that? Because that's one of the things that makes me wonder about the necessity of this. Can you address the elevator subject again?
Elevator is completely broken. And so it would need a whole new elevator system to be put in.
Yeah.
Mm-hmm.
And then second of all, you still would require an elderly man that is fighting for his life to do a 5-point turn in his driveway from that basement entrance once he gets down there to go back out onto Rock Spring Road. And I just, I don't get it.
I have a follow-up question just about, what you're talking about, the 5-point turn and everything. And we've talked about his disability and his doctor. Is there any prognosis at this point about, when just due to his illness, if his doctor's going to advise him not to drive, if he'll have to have someone else drive for him. But is that in the mix at all? Have you heard of any prognosis?
I got great news today when I saw him tonight that he changed doctors from the VA that had totally blown his chemo. And they've got him on the right chemo. And right now, knock on wood, I think he's fighting the good fight.
Okay.
He drove here tonight. He's sitting out in the back. He has no hair, and but he looks a lot better than when I saw him at his home 2 months ago.
So it's for the foreseeable future? At least that's what the hope is, it sounds like.
He will be mobile and hopefully battling cancer and winning.
Okay, thank you.
Other questions? Mr. Owen?
I'll just want to note for the record that we have had 2 previous hearings on this, so I don't have as many questions as I might usually, because I feel like I'm well informed from those previous hearings.
Mr. Smith?
I do have a question, and I'm wondering, what is the status of and I presume you had to make application to VDOT for to create a new apron?
I'm not aware of that yet, of if there has been an application yet to get a curb cut. But in Arlington County, doesn't Arlington County control its streets?
If they do, or it's...
Yes, it's...
Okay.
It's different than as someone already ratted me out as a former transportation commissioner, right? So this street and most other streets in Arlington are controlled by the county, not the state, which is atypical in Virginia. Only us in Henrico County control our own streets, with some exceptions, but this is not one of them.
I was involved in a case in Fairfax, and it was all VDOT and not Fairfax. So for some reason I was thinking. But has application been made to Arlington for a curb cut?
Not until we get this approved.
Okay.
Other questions? We have 2 speakers. Stand by. Andrew Smith, to be followed by Ellen Dwyer.
Members of the board, I live on the right side of the picture of the applicant. The issues I have with this is I've lived in my house for 19 years. I've raised 3 kids in that house. Nobody's ever had a wreck on Rock Spring Road pulling into or backing into our driveway. We all learned how to back in. It's not a terribly busy street. It's just not. Number 2 is compatibility with the neighborhood. I've had to live with this since February. I look at a plat, and it is just a plat. It is not a site plan. It is not a developed plan. And I have no idea what's going in that. It's a nice, established, older neighborhood. My house was built in 29. So today, while I understand the reasons and I understand where they're trying to go with this, we keep seeing the same thing over and over and over again. We've spent a bunch of time. We have tried to work with the applicant to no avail. So my point here is this. There's consistency with the neighborhood. I'm not really sure that the issue of pulling out onto Rock Spring Road is a big issue. I'm sorry the applicant has cancer. I really am. And I would like to work with it to get something to work, but it's like Groundhog Day. That's it.
Thank you. Ellen Dwyer?
I think you have the letter that I submitted that had some attachments, so I'm not going to repeat everything that's in there. I do think that no one's interested in not being compassionate here, but the law actually does matter. And the law is quite clear, and which is why I support the staff's report on this. I would just direct your attention to Exhibit 1, which goes to the issue of alternatives. In order for the BZA to grant this variance, there actually has to be a finding that this is a necessary accommodation, not a reasonable one solely, but actually necessary, and that there are not other alternatives that would serve as an appropriate accommodation. And as you look at Exhibit 1, which is the plat submitted by the applicant, in our view, what's being proposed is redundant as to what exists. I mean, you just can look at it and you can see that the turnaround radius and the distance is the same as what exists in the current driveway with the current turnaround radius, which to me demonstrates that adding another driveway and another parking area is not necessary. And then the third point, which is referenced on Exhibit 3, is that this goes to the neighborhood. This is not a commercial neighborhood, notwithstanding what you're seeing in this picture with equipment, which has been there since February. This is not a commercial neighborhood. This is a beautiful neighborhood with lovely homes up and down this street. And though it doesn't go to the county's lot restrictions, you can see on this drawing that the impervious space that already exists, the surfaces that exist on this property, are quite out of character with the neighborhood. So the idea of adding another 886 feet of concrete on a property that is already, if you take all of that in total, it's 80% of the property being covered in concrete, which is incompatible with the neighborhood from our perspective. I also think I just wanted to point out, there was a question at a prior hearing, that you had inquired about, was there any precedent for granting an accommodation, giving someone a driveway and a parking space under the ADA or under the FHAA? I've looked at that. I can't find anything like that. As you would expect, there would be railings, ramps, other accommodations.
Thank you.
Thank you.
Okay, no more speakers. Any comments or questions?
Madam Chair,
Mr. Smith.
I would just say that, the use permit burden is lower than the variance burden. And I've been on the BZA a long time. We repeatedly say, well, we understand the need for you to take in your parents or to age in place and the like. It's over and over and over the years. There have been folk who've come in with arguments for medical necessity, but the code doesn't give that as a basis for granting variances. That's a much higher burden. Not as high as it used to be, but still higher than that for a use permit. I was back then, I know I missed one meeting during the course of these proceedings with respect to this application, but I think this is the third. So
At least.
my mind has not changed from the beginning when I was uncomfortable with it.
Thank you. Any other comments?
Yeah.
Mr. Melnick.
Okay. So I'm struck by the point in Ms. Dwyer's submission.
Yes.
Just about it's rather identical. How many point turn it would take, whether the existing driveway or the proposed additional driveway. It would generally be, a 2-point turn from a parking position on either, and that's what I'm struck by. It just seems, one shorter than the other. There's a little more driving with the driveway, but it just seems like the amount of points turn, to get to a forward-facing position going out would be about the same. So, yeah, one does involve a garage, but still.
That could be removed if you really wanted to have maximum flexibility. Any other comments? Motion?
Madam Chair,
Mr. Smith.
I guess I would move that the Board of Zoning Appeals adopt the attached resolution denying V-11090-15-VA4.
Second? Is there a second?
I'll second.
Thank you. Moved by Mr. Smith, seconded by Mr. Melnick. All those in favor?
Aye.
Aye. Opposed? Thank you. Next case.
The next case is V-11164-16-UP-1. It's a carryover use permit request by Payam Far, owner to permit a setback of 11.9 feet to the eave and 12.6 feet to the porch base from the 8th Street North right-of-way instead of 21 feet as required, and a setback of 0.2 feet to the air conditioning unit from the left side property line instead of 5 feet as required for the reconstruction of an existing front porch and to maintain an existing air conditioning unit at its current location in the left side yard. The property is zoned R6. The premise is known as 3518 8th Street North. The staff recommendation is to adopt the attached resolution denying the 0.2-foot setback for the air conditioning unit to the left side property line, but granting a use permit for setbacks of 11.9 feet to the eave and 12.6 feet to the porch base from the 8th Street North right-of-way.
Okay, any questions for the staff? Hear from the applicant, please.
Good evening, everyone. Thank you for hearing the case. The home's been in the family for quite some time. I just took it over about a year and a half ago. So in my novice attempt to make some home improvements, I didn't really know I was out of compliance. And I worked with Summit Environmental to try to refurbish the front porch. And last October, if I recall, there was a violation that the wood columns were paint chipped, and that's when I realized, or when I was notified that the setbacks do not comply with zoning. In my naivety, I just ask forgiveness and look forward to working with the county to sort the issues out.
Mr. Owen.
I have a question.
Yes.
So thank you for the materials that you gave us to prepare for this hearing. I noticed that you had signatures from 3 of your neighbors,
Yeah.
but missing was any comments from your neighbor to the right, immediate right, 3522. Do you know why we don't have any comments from them?
That property is being rented, and the tenant didn't. The tenant gave me the contact information for the homeowner. I emailed him twice and sent him a copy of the notice that was sent by Arlington County with the violation and also the attached letter of support, and I hadn't heard a response since.
Okay.
So also there's another property behind the house that's diagonal on 7th Street, 3515 7th Street, and that appears to be vacant.
Thank you. Thank you for that explanation.
Yes. So I noticed in your submission, because one of the objections of the county was the air conditioning unit. So are you going to have that not be an issue?
Yes. Actually, tomorrow there's a company, K&J Heating and Cooling, that's going to drop by to look at how to move it, because I guess there's some stuff in the basement that has to move with it.
So are you planning tonight on dropping that request from the application?
That'll be taken care of to try to comply with zoning.
Okay. Thank you.
Any questions? Mr. Owen?
I'm prepared to make a motion, Madam Chairman.
Well, we have 2 speakers. Okay. Well, no, this is the applicant. Donna Abraham?
Good evening, everybody. Thank you for letting me take a minute. It won't take long. We're Summit, and we're going to also be taking care of those columns. And I just wanted to stress that we're very happy to fix the violations and get everything in place. That it was. And
Would you state your name, just for the record?
Sorry, Donna Abrahams.
Thank you.
What's your address? What's your connection with the property?
I'm actually with Summit Environmental.
Oh, okay.
Yeah, we were one of the ones that was helping refurbish the front porch. And that's when we realized the columns needed some work. And started the process, but he had already gotten the violations, so that's what got the ball rolling. So I'm just here to state that we will get everything taken care of on the front porch part. The
Thank you,
columns
thank you.
specifically. Yeah, thanks.
Okay. Mr. Owen?
Thanks. Madam Chair, I, in the matter of use permit V-11164-16-UP-1, I move that the Board of Zoning Appeals adopt the attached resolution, the staff recommendation, denial of air conditioning unit, approval of front porch as found in the staff report.
Second.
Moved by Mr. Owen, seconded by Mr. Smith. All those in favor?
Aye.
Aye. Opposed? Thank you. Next case.
Next case is V-11167-16-UP-1. Is a carryover use permit request by David and Patricia Copenhagen, owners, to permit a setback of 6 feet to the left side property line instead of 8 feet as required, and 8.4 feet from the rear property line instead of 25 feet as required, to maintain an existing raised hockey rink in its current location in the rear yard. The property is zoned R10. The premises is known as 4524 35th Street North. The staff recommendation is to adopt the resolution to deny the subject use permit.
Thank you. Questions for the staff? Mr. Owen?
At the last hearing on this item, there were a list of conditions that we talked through verbally, and it's not clear to me whether or not we have any kind of draft resolution prepared with those conditions or any staff analysis of those conditions. Do you have anything further for us in terms of guidance?
It was included in the staff report. It was towards the end. There was a set of conditions that was sent by email on September 2nd. It just wasn't received in time to draft in order to get the staff reports, the resolutions drafted and included. So it's on the second last page of the staff report. So it was really
Page
just a
title,
matter of...
Copenhagen Practice Hockey Rink Use Permit Conditions.
Correct.
Do you, have you now reviewed those conditions?
Yeah, we've reviewed them since. None of them would appear to be in any way a problem as far as like enforcement or legally undefensible, if this were to...
So all of them would be lawful and enforceable as far as you can tell?
As far as we can tell, correct.
Okay. And who submitted this page that says Copenhagen Practice Hockey?
This was submitted by the neighboring property owner, Diane Polak.
These are proposed by the neighbor?
Correct.
And were not received from the Copenhageners?
Correct.
Okay. Thank you.
It's in reverse order.
Right, okay.
They were copied on it, though, it looks like, Madam Chairman.
Yep. Thank you.
Okay.
Yeah, and I also spoke with their attorney, Evan Pritchard, about this email, and apparently he had relayed to me that they had spoken, that these were done in collaboration with the Copenhagen, so it was it wasn't just strictly drafted and sent along, so.
Okay. Thank you.
Do we have
Yes.
any speakers on this item? Besides the applicant?
The applicant.
Oh, not besides the applicant, apparently, no.
Okay, thank you.
May we hear from the applicant, please?
Good evening. My name is David Copenhagen. I'm the property owner at 4524 35th Street. Just to add some clarity, we drafted the restrictions with the Pollocks, and I believe we actually submitted them independently, so it would be clear that they were in agreement. So I think Mrs. Pollock's email probably had a copy of the same that I submitted to Mr. Noxon earlier this month.
Okay.
And I guess if I could add one other thing, that the list of restrictions was precisely what we discussed when I was here last month. We took point by point what the board members had suggested.
Thank you. Questions for the applicant? Thank you. There are no speakers.
Madam Chair, I would move that we take a 3-minute recess so that I might prepare a motion.
Okay.
Second. I'll give Mr. Owen that. I had drafted one briefly, but I'll.
Okay, 3-minute recess.
Thank you.
Unanimous. Hippy skippy.
Treats in the back. Don't forget the treats.
So we are right here. All these to come. Yep. The record is about. Yeah. Okay. So the record. What is?
In terms of noise and lights and are people going to be calling the county every 20 minutes to try to deal with it? Okay, what happened to the lights? Killed them. Well, but it is, I mean, this is low light for me. Yeah. No, it's okay. I've read the homework. I don't need to. It's getting dimmer. It's too dim.
The ceiling lights are the ones.
It's too dim.
There we go. That's it. Put those at the maximum.
Is that maximum? I think we need even more light. Still some dim.
Yep. There you go. That's decent. That's pretty good, yeah. Okay, that's good. That's good. Thank you. Go get Charles. Here he comes. Okay, ladies and gents, we're back. Do we have further discussion, questions? You almost ready? Mr. Owen.
Madam Chair, I am prepared to move a version of the alternative resolution for approval.
Go ahead.
So I think just for case I have miscounted noses here, I'll just make a motion, then I'll offer to amend it with the conditions that we were just talking about. So first, intending to make a further motion for adopting conditions, I move the alternative resolution for approval.
Case number?
Second.
Oh.
Excuse me?
In case number V-11167-16-UP-1, I move the alternative resolution for approval.
Second.
Moved by Mr. Owen, seconded by Mr. Smith.
I move to add an additional condition 4 to read as follows. The applicants agree to maintain the improvement subject to all 6 conditions submitted in the staff report section titled Copenhagen Practice Hockey Rink Use Permit Conditions, including an expiration of the permit on August 31st, 2026.
Second.
Okay, so do we have one motion?
Well,
do
I
we have-
moved it as a separate amendment, so we need to vote on the amendment.
Okay. Let's vote on the amendment first.
Sorry about that.
No worries. All those in favor?
Aye.
Aye. Okay, main motion.
Let's proceed to
Any
vote.
any discussion? Okay. All those in favor of the motion, alternative resolution as amended with condition 4?
Aye.
Aye.
No. It's approved 3-1. Thank you. Next case, please.
The next case is V-11171-16-UP-1. It's a carryover use permit request by Ruben Miranda, owner, to permit a setback of 5.6 feet to the porch base from the right side property line instead of 8 feet as required, and an 11.6 foot setback to the eaves of the porch, and a new second story addition, a 12.1 foot setback to the porch base, and a 15 foot to the bay window, 16 feet to the eave, and 16.5 feet to the wall of a new 2-story rear addition and side porch from the South Ives Street right-of-way instead of 25 feet as required, for a new 2-story rear addition, a left side porch, a front porch, a left side bay window, and eaves from the new second-story addition above the existing first-floor walls. The property is zoned R5. The premises is known as 900 17th Street South. The staff recommendation is to adopt the attached resolution granting the subject use permit with conditions.
Thank you. Questions for staff? We hear from the applicant, please. Oh, good.
Hello, my name is Ruben Miranda. I'm here to see that my application is approved by you. Thank you very much.
Any questions for the applicant? Thank you. No speakers?
No.
Thank you.
Can I make a motion?
Mr. Melnick.
So I'd like to make a motion that in case D1117116 UP1, that the Board of Zoning Appeals grant and approve the attached resolution approving the use permit as applied for.
Second.
Moved by Mr. Melnick and seconded by Mr. Smith.
Yeah, if I meant to add with conditions, as stated.
Right. All those in favor?
Aye.
Opposed?
No.
Thank you. Next case, please.
Next case is V-11173-16-UP-1. A use permit request by Ryan and Jennifer Miller, owners to permit a setback of 13.1 feet to the eave and 13.4 feet to the wall of the home from the North Culpeper Street right-of-way instead of 25 feet as required, and a 17.4-foot setback to the areaway and a 23.6 foot to the wall of the home from the rear property line instead of 25 feet as required. This is for a new second-story cantilevered front addition and a second-story addition above the existing home, and a new two-story rear addition and a new rear areaway. The property is zoned R6. The premises is known as 1744 North Culpeper Street. The staff recommendation is to adopt the attached resolution denying setbacks of 13.1 feet to the eave and 13.4 feet to the wall of the home from the North Culpeper Street right-of-way for the construction of a new cantilevered second-story addition to the front home, but granting a use permit for setbacks of 18 feet to the eave from North Culpeper Street right-of-way and 17.4 feet to the areaway and 23.6 feet to the wall of the home from the rear property line for the construction of a second-story addition above the existing home, a new two-story rear addition, and a new rear areaway with conditions.
Thank you. I did want to make one point that this is a carryover. We did see this before. But in the staff report under previous action, it says there were none. So that is confusing and inconsistent.
Okay, I see.
Yeah. Okay. Any questions for staff? All right. We hear from the applicant, please.
Madam Chair, members of the board, thank you so much for this opportunity. This is my first time to speak in front of the BZA, and it's my son's first opportunity as well. So thank you for welcoming us here. I moved to Arlington last October.
Just state your name, please.
Sure. I'm Ryan Miller, my wife Jennifer, and my son Nathaniel. In October of 2015, I moved to Arlington and have really been welcomed by the community of Highview Park and the greater area. And as public servants, my wife and I really have valued the community as it stands, a historic place that brings a lot of people from a lot of different walks of life together. And as we've joined our community members for barbecues and celebrations over the last 11 or 12 months, we've been really struck by the sense of consciousness and scale and layout that defines the community. And as a growing family, we knew that we would probably need to make some changes to the home as we bought it. And we've been really warmed by the outpouring of support from our neighbors. We received 19 letters with 25 signatories, 4 of which have lived in the neighborhood for 50 years, supporting the plans that we've submitted. And so that, in particular, in many ways, helped us understand that that we had put forth a proposal that was sound and would be welcomed by the community. Furthermore, we sought to find a partner in this project in Carnamark Design and Build, and really were struck by the proposal that they put forth, in part because of the environmental consciousness that they emphasized and really wanted to employ in the plans that they helped us create. And so I want to commend them, but also ask Patrick and Josh, who are both the project manager and designer, to come speak. I'd like to conclude by saying that we're committed to the community and committed to the neighborhood. We really love it. I have traveled around for 15 years and lived in cities in the United States and abroad. And for the first time in my adult life, I feel in many ways as if I'm home and really feel that sense of community. And it's made an important impression on myself, my family, and I'm pleased to be speaking in front of you and really want to thank you for the work that you do, and would like to invite Josh and Patrick up at this point, if I could.
Thank you. Just a moment. Are there questions for the applicant? Okay, we have 4 speakers. Patrick Harold, to be followed by Joshua Van Dengen.
Good evening. My name is Patrick Harold. I'm from Carnamark Design Build. We've worked hard with Ryan and Jen Miller to develop a modest plan that will allow them to raise a family in a community that means so much to them. I believe you have numerous letters and signatures from their neighbors and remarkably unanimous support of the project. We also have a letter from the Arlington Green Home Choice Program supporting our environmentally friendly design. I'm here to dispute the analysis that led the zoning coordinator to recommend against our proposal. We're requesting to build a second story above an existing covered but open front porch at 1744 North Culpeper. This proposal is entirely in keeping with the character of the neighborhood and does not put the house any closer to the street than it effectively already is. Although the coordinator used only the 2 adjacent homes for justifying his position in the staff memo, if you include the 3 houses opposite the 3 houses on this side of the street that he's discussing, that puts our proposed second-story setback squarely in the middle of street-level setbacks and about 1 foot from the average existing setback on that part of the street. As the coordinator notes in his report, most of the homes on this block of North Culpeper Street encroach into the street setbacks. I think a more comprehensive analysis of the data that he provides proves that we aren't requesting anything that the BZA hasn't already approved on this block. If you look at the table of previously approved use permits on page 2 of the zoning coordinator staff report, our request is again about 1 foot closer to the street than the average approved setbacks in this neighborhood. Nearly 40% of the approved setbacks are closer to the street than our proposal. And in fact, 1 second-story cantilevered addition directly across the street was approved at less than half the distance that we're requesting. The proposed expansion also makes sense by utilizing the existing structure of the home, and we're able to increase the size, value, and livability of the home without any significant increase in the footprint of the house. Our proposal to minimize lot coverage is far preferable from an environmental standpoint to increasing the size of the house at the back. The manager of the Arlington Green Home Choice Program wrote in favor of our proposed addition, applauding it for contributing to the county's goals for reduced energy usage and water quality.
Would you sum up, please?
Yes, ma'am. On a block that's defined by wildly varying setbacks with an existing layout that discourages an addition in the back, it seems reasonable that the Millers should be allowed to build above the existing front porch, and we ask that you approve the alternative resolution and allow the Millers to proceed with the design as proposed. Thank you.
Thank you. Joshua Van Dengen, to be followed by Karul Vampe.
Thank you. I'm Josh Van Dong. I'm an architect with Carnamark Design Build, and I am here to support the proposal and also here to answer any questions that you may have. I will just speak quickly to your question about the carryover. There was a advertisement of this proposal where the setback was listed in air, and that was done, I think, at the last minute, and so by the time we had found out about that, it was postponed to this meeting. So,
Thank you. Kirill? Be followed by Jessica Hawkins.
Hi, my name is Kirill Vampi. I live right next door at 1740 North Culpeper Street. I've been there since November. Ryan and Jennifer are wonderful neighbors, very important part of the community. As was mentioned earlier, I believe this is a modest addition, environmentally friendly, does not pose any hazards to anybody, and is not opposed by anybody in the community. As was also mentioned, the house may be less than 25 feet from the road, but many of the homes are 1, 2, 5 feet from the street. So it would be very similar to the other setbacks, and the addition would also conform to the rest of the character of the neighborhood. It would not create any imbalance or anything else. So I'd like to show my support for this addition. Thank you.
Thank you. And Jessica Hawkins?
Hi, so I'm Jessica Hawkins. I'm a neighbor of Ryan and Jen's. I live at 1836 North Culpeper Street. And I wanted to speak in support with some comments. I have lived on North Culpeper since 2008 when I was married. I started dating my husband in 2006. We built a home on our also smaller lot last year. One of the interesting things I noticed about the zoning code is our street. The picture that appears on the zoning code PDF cover is actually of our street. It's pretty interesting. And you can see Waycroft Woodlawn, which is neatly aligned. You can see Highview Park, which developed in an interesting way. And we have these non-conforming lots. Jen and Ryan's is 3650 square feet. That has led, and I firsthand know the difficulty as I was the general contractor for our site work, and I've dealt with all the invoices and bills. There are certain fixed costs with building. And that's why spec builders are not buying the small lots and dealing with that, because there are certain economies of scale. I built a not so large house myself. That has led to vacant houses on our street. And we currently have 2. I haven't kept track, but I think it's been over 2 years for 1721, which is a foreclosure. 1817 has been another one. We have another one up the street by the Heidelberg that's been vacant for quite some time too. I have a child who's the same age as Nate, similar, just about a year younger, not quite 3. Vacant houses are a risk for crime. These are the issues that our street is dealing with. Ryan and Jen's proposal fits in very well with the community, keeps their front porch, which has enabled them to get to know a lot of neighbors, including us. And I 100% support it.
Thank you.
Thank you.
That's the last speaker. Comments, questions?
Madam Chair.
Mr. Owen.
The staff report indicates no comments received from neighbors, but we received a package of materials at our places today with some comments from neighbors. But I'm not sure if I'm missing or not is typically we have comments from the immediate neighbors, the ones who could see it from their houses. And I'm just wondering, am I missing that in the packet that we got today, or is that not something that, do we not have comments from the immediate neighbors abutting, adjacent, across the street? Go ahead.
Sir, thank you so much. We have a letter that we have submitted to Amanda today for processing. I have hard copies. We've also submitted e-copies. This letter that affirms support for the design as is was signed by both neighbors on either side of us, the neighbor directly across from us, and a lot of the neighbors in very close proximity, including the neighbor that is behind us on North Cameron Street.
What about the neighbors across the street?
Yes, they signed an affirmation.
And so is that in, did we get that? Did that come through you?
What we have printed up here are the individual emails that were sent directly to me from those who were supporting your case. The larger document, as we discussed, that came towards the end of the day, you were going to be providing the hard copies?
Oh, yes, no, I have the hard copies right here. I didn't know maybe the right adequate way to submit those for the record, but I did submit them to you by email today at about 11 a.m.
If you have hard copies with you, I would love to see them.
Sure, thank you.
Thank you. One set of 19 signatures.
That's correct. So there's 19 documents, and I believe 25 or 26 signatures, and some households had multiple signatures per household. And it does stipulate, interestingly, on the letter, the years that people have been in Highview Park. I think is a testament in some ways to the fidelity of the community, but also the broad support that we've been able to enjoy.
Thank you.
Thank you.
Questions, comments? No?
Madam Chair.
Mr. Owen.
So on this application, I certainly agree that this street and this part of this neighborhood does have what appears to be extremely unusual characteristics. And it is true that some of the houses across the street have setbacks of next to nothing. And so a usual key criteria for use permits for us is what you're doing going to seem out of place for the neighborhood? And I think, as I understand it, the applicants here are making the argument that since many of the other houses are extremely out of compliance with the setback requirements for their zoning category, that this one also being extremely out of compliance is compatible with the rest of the neighborhood. I think that is a relatively strong argument on that point. The question is then, we're not supposed to take these use permits to the point that it's tantamount to a rezoning. And that's the area where I feel like I'm more inclined to go with the staff report than the application, because I do think that perhaps this street has such unusual characteristics that it deserves treatment by the county board as a zoning policy discussion. These lots are just really not, they're similar to each other but different from the rest of R6. And so there are other policy considerations besides compatibility with what is normal for the neighborhood, such as fire control and safety and the ability to get rights of way for utilities in the future, and all those sorts of things. And I feel a little bit concerned that a practice on this street of continuing these very short two-story encroachments onto the street becomes a broader policy decision. So I'm more inclined to support the staff recommendation.
Madam Chair.
Mr. Smith.
I'd like to hear the applicant react to the staff's recommendation.
Yes.
Because Mr. Owen makes a good point that it is so odd that maybe it does deserve a big look. But I'd like to hear the applicant's reaction to the staff.
Sure. Thank you, Mr. Smith, and thank you, Mr. Owen, for your comments. I think the way I would respond is to maybe put a little bit into context about the current setback as it stands with the porch configuration, and just make a general comment about how much we utilize that porch. Our current structure, the living area is, I believe, 708 square feet, and with a 3.5-year-old, that sometimes poses logistical challenges for things such as dining in the evening. And so we use the front porch regularly and vigorously for meals and for gatherings and certainly when we have friends over. And I think in some ways it doesn't, we're very safety conscious and the setback to us as it currently stands with the porch, and I believe the porch was installed on the property in 1990. We purchased the property, of course, in 2015. To us, in many ways, feels appropriate for the scale of the lot. It's a pretty small lot as well, and so from a scalability, I'm not sure it would be precedent setting necessarily, although you know much better than I about the message it would send to the relationship with the other houses as much as the relationship with the lot itself. And I think from living in the house for about a year, I can tell you, that universally the setup of our home and the position on the lot actually really works for us. And I think in some ways, the front porch, there was a determination, I think, that had been made in the report, which I don't agree with, which is that we would demolish the front porch. And I think that was an overstatement in part because it's the front porch to us that really makes this property. And while it would be slightly, sort of redesigned aesthetically, the porch as a gathering area, as a place to interact with the community, as a place to be able to, watch our son as he's, reading a book or playing in the yard before us is really a vital part of the home. And so I think to some degree this is a unique case, and I acknowledge that, and it's a unique property. But I think what we've proposed is modest and reasonable in regards to the lot as it is sized, and it doesn't interfere or have an adverse effect with the neighborhood as it is now.
So as we look at the house, when improved, it would be the same setback?
Yes, that's correct. As I understand, yes.
Given the aerial view that we saw of the setbacks directly across from you, which looked to be closer to the street than your house. And I'm very familiar with that neighborhood and block, and it's a patchwork quilt of setbacks. So I'd be inclined to say, so long as it's no closer or larger, I'd support it. Other comments, questions, motions?
Well, Madam Chair, let me float a motion, and it's going to be the alternative, which is
as advertised.
Madam Chair, in the case of V-11173-16UP1, I move that the Board of Zoning Appeals adopt the alternative resolution, which would grant the application as advertised, subject to the conditions listed in the alternative resolution.
Is there a second? I will second. Moved by Mr. Smith, seconded by Ms. Freshman. Discussion? All those in favor? Aye. Opposed?
No.
No.
Tie fails.
Chairman, in the case of V-11173-16-UP1, I move the staff proposed resolution approving the construction in the rear and disapproving the two-story addition in the front. Specifically, denial of the cantilevered second-story front addition, approval of the eave for the new second-story addition above the home, rear two-story addition, and rear areaway.
Is there a second?
So just to clarify, that's just the resolution that the staff is putting forward?
Yes, I'm moving to recommend the staff. I'm moving to approve the staff recommendation.
Okay. Yeah, I'll second.
Moved by Mr. Owen, seconded by Mr. Melnick. All those in favor?
Aye.
Aye.
All those opposed? No.
Okay. Madam Chair, let me try a deferral, because I think, given kind of an issue with, let's say, how the overhang, the cantilever, and you've done a lot of design work, and you have excellent design build folk behind you. Perhaps they can come with something different in the future, if you would entertain that, if that would be something you would consider at all.
They could even come back with something that's the same and have an odd number of BZA members.
Well,
I wasn't suggesting that, but that's possible too. But
if you go to October, INTA may be here, but I will not. So you could still have 4 people.
I think they would need more than just October anyway, because the advertising period.
I mean, I'm very sympathetic to this application. I understand why you're applying. I think that it's not an unreasonable, from your perspective as an individual homeowner, I don't think it's an unreasonable request. I just feel as a matter of zoning policy that this street is go, and that the BZA is the wrong way to slowly accrue, no more right-of-way in the street. It's really, I feel troubled, because I think from your perspective as an individual homeowner, I want to treat you fairly, and I don't want to drag this out and have it last months and months and have you be in doubt about trying to build a home for your family. So I
2 months?
Whatever the applicant thinks they can work with.
Okay, let's have a motion.
Madam Chair, I move we defer V-11173-16-UP1 till the November meeting of the Board of Zoning Appeals to give the applicant an opportunity to perhaps redesign and come back before the board with perhaps something different.
I'll second.
Moved by Mr. Smith, seconded by Mr. Melnick. All those in favor of deferral to November?
Madam Chair.
Mr. Owen.
I just want to ask the applicant, do you understand what we're doing, and is 2 months sufficient time? Because we wouldn't want to have you come back time and time again. Do you think that 2 months is sufficient time for you?
I think maybe, Mr. Owen, before I answer that question, I would just seek to answer Mr. Smith's question about, the ability for me to continue to do design work. As I mentioned in my opening, my wife and I are public servants, and this has been a big step for us to go through this process. It's been a financial burden. We've spent, a lot of our savings, candidly, on this. And, I approach this soberly and with an open mind, and this has been an interesting process as a member of the community to follow and to process. And I will say that the burden of further design work and further design machinations feels daunting to me, because I feel to some degree that in partnership with my design firm that we've hired, we've sought to come up with a design that stays within the existing footprint of the house. And I think we felt, and certainly I felt as a layman, that would be a relatively, if not surefire, a reasonable way of approaching a modest design like this. And so I certainly would respect the idea that the board would postpone this decision for a couple of months, and I appreciate that you would give me the time to sort of reconsider. But on the other hand, that would be, I think, an enormous burden financially for my wife and I, and cause quite a bit of stress in a situation that I think we thought we weren't trying to build outside of the character of the community, and through this process have found that we actually enjoy almost unanimous support from our near community, and the outpouring and the support from our community in and of itself has been worth this process, I'll tell you. But I would just sort of humbly submit that, with months of delays and additional design work, I think that will put quite a bit of stress, financial stress, and just, sort of emotional stress on my wife and I, and ultimately we'll respect your decision, but I would just want to sort of make that statement for the record.
Well, let me ask just one other thing then. Would it be less burdensome for you just to get the staff recommendation and have it be over with? I mean, we could move for reconsideration of the previous vote if you'd prefer that.
I mean, I think for us, Mr. Owen, the recommendation of the staff that the staff made is exceedingly burdensome and calls into question whether we can, do the work as it is, in part because our home right now is 708 square feet. It's a small home, and so we're basically within the existing footprint of the home without having to do, a lot of the cost and additional work. And I'll defer to my my partners here to go into greater detail about the cost and scalability. But the way we understand it is to keep the footprint of the home while also achieving the necessary square footage to support our growing family. That this was the design that sort of married those two things together in the best way possible, in the most aesthetically pleasing way possible, and also, again, to sort of show respect for the community and our community members, who would both see our house and live on the neighborhood where our house stood. And so I would maybe defer any further questions of cost to the designers, but just from a sort of a qualitative standpoint, I really think that to adopt the resolution as the staff presented it would be really burdensome and I think call into question whether this could be a home that we could grow in, to be honest.
Thank you.
Madam Chair, if I might
Mr. Smith.
address the applicant. Well, Mr. Owen kind of in part suggested that you could come back with exactly the same thing as Plan A in the event that doesn't meet, get 3 votes. You could have a Plan B. That's all I'm saying, that right now you just have Plan A and it's deadlocked.
Essentially, your floor is the staff recommendation. It doesn't. It's my assessment, although not a promise, that you'll get no less than what the staff is recommending today. Okay. You come back in November, you might get everything you're asking for when we have an odd number of votes, but you might not. You might be back to the staff recommendation. And so what Mr. Smith is suggesting is, since it looks like we are going to go to November, you might also want to have a third option on the table that might increase your chances of getting more than the staff recommendation. Do you have additional points to add?
I have a question, and I also, if this is the appropriate time, I can explain why there would be some difficulty in terms of just the programmatic layout and the structure of the existing home. I understand that we are not going back to revisit that vote, so I'll hold those comments. But I would be curious to hear what Mr. Melnick has in his mind as the reason that he would not support the proposal, so that we can go into the next meeting with some thoughts about that objection.
Well, as far as my thinking is that I think that it's important for this body, just like the questions say, basically the first question, would this promote compatibility of development with surrounding neighborhood? And on this side of the street, the averaging, that's what struck me. And then the overhead shot. So, and I'm looking at the overhead here, and I think we're here to just make sure there is compatibility. And if of course the more we approve things closer and closer to the street, the more things will get closer and closer to the street. But then it does almost seem like a rezoning, like Mr. Owen was saying. So that's my main point here. It's just the compatibility, and and I understand about building and about needing space and families and that sort of thing. So, that's my main point. It's just the compatibility element.
Other questions, comments? Okay. So we're voting on a deferral to the November BZA meeting. All those in favor?
Aye.
Aye. Thank you. See you.
Thank you.
Next case, please.
The next case is V-10995-15-UP-3. It's a use permit amendment request by Frederick Sujat, owner, to permit alterations to an existing two-story right-side addition approved by a previous use permit. The property is zoned R6. The premises is known as 5010 Washington Boulevard. The staff recommendation is to adopt the attached resolution granting the use permit with conditions.
May I ask what happened to the public schools, which was next on the agenda?
Do we have to take action on the withdrawn variance request from Arlington County Public Schools?
I couldn't remember if we actually act on the withdrawals, but I can read it.
We typically have, so.
Sorry about that.
Sorry, wait. Yes.
Okay.
So case V-11175-16-VA-1, a variance request by Arlington County Public Schools, the owners to permit a setback of 42 feet from the center line of Patrick Henry Drive instead of 50 feet is required, and 7 feet from the Patrick Henry Drive right-of-way instead of 25 feet is required, regarding 2 new relocatable classroom trailers in the southeastern corner of the property, located in the S3A zoning district at the premises known as 5800 Washington Boulevard. And the applicant has formally requested a withdrawal.
Motion?
Well, Madam Chair, before that, I want to ask, have the trailers been, have they put trailers there but somewhere else on the property?
There are 2 right on the street. I saw them yesterday.
There were several relocatable locations. Is this the one that went to HLRB? Okay, so this location is in a historic district,
yes,
and there's a separate process that allows that board to grant setback deviations. There's an administrative process if you're in a historic district that the HLRB can review.
Well, they have to. My impression was you have to go through the HLRB and then come to us.
So the HLRB has already. It's administrative approval. So the HLRB they heard this at their August meeting and granted the setbacks.
They have the power to grant variances?
They have the power to grant variations from setback requirements in historic districts.
Which explains why they're already there, apparently. Okay, let's go.
Madam Chair. Madam Chair, I move that we accept the withdrawal of the subject variance.
Second.
In case number V-11175-16-VA-1.
Thank you. Moved by Mr. Owen, seconded by Mr. Smith. All those in favor?
Aye.
Thank you. Now then, back to Washington Boulevard. The case has already been read.
Would you like me to read it again? Or?
No, we'll stipulate that the case has already been read. Come forward, please. We hear from the applicant. Thank you.
May I please share these?
What is that?
Letters of support or pictures? Sure.
Sure.
We get to keep them, though.
Thank you.
Okay, thank you. Okay, go ahead.
Good evening. I am Frederick Sujat. This is my wife, Tia Sujat. And we are the owners of the home on 5010 Washington Boulevard, and we are constructing the new addition, which was approved by this board. Our proposal is very modest, and it's non-impactful to the neighborhood. And actually, it would be very beneficial to us. It would also be compliant with the code and the law, and it is supported by the staff. Our proposal is to move the second floor addition window on the back, which is the south side elevation, slightly to the left. The result is that the black block glass window of 5 foot 8 inches by 5 foot 8 inches would be slightly repositioned and become a smaller regular glass window, 3 feet by 8 inches, 3 feet 8 inches rather, by 3 feet, and it's all set forth in the drawings that we presented. The change is necessary due to an interior change, which is a reversal in the positioning of the shower, stall, and tub on that wall. And it's at the insistence of the plumber and general contractor, basically to avoid having the pipes freezing in the outside wall. So the change, again, is very modest. There's no expansion of the footprint and no encroachment at all on the setback. Do you have anything to add?
Yes.
Mm-hmm.
As my husband explained, we were encouraged. Could you speak into that? We went to the permit.
Microphone.
Could you speak into the microphone, please?
We were encouraged to do that by both the plumber and our contractor. And when we went to the permit office, they said there was no problem, that it was very common that when people encounter problems or make modifications like this, minor modifications, that it was absolutely not a non-issue. If you look at the pictures, please, you can see picture number 3 and 4, 3, 4, and 5. And you'll get an idea why they moved it, because the plumbing would have been on the outside wall, and so they wanted to reverse it, and we did. You see the shower and the window, and it's a smaller window than if you see picture number 6. If you see that, you can see where originally...
Excuse me, just for clarification, did you label the pictures on the back?
I
with
did.
numbers?
I did. So number 6, you see the window. And what's interesting, if you look at pictures number 7, this was taken from our guest bedroom that's facing actually Mr. Feely's house. You will also see to the left of that, there's a neighbor's house that has 2 bedroom windows upstairs. Additionally, if you look at pictures 8, 9, and 10, you will see that the neighbor to the left of Mr. Feely's house just put this new addition. They just completed it, and they have, as you can see, there are 4 windows, 2 upstairs and 2 downstairs. So when you look at picture 7, you can see the neighbor to the left of his house, facing my back window upstairs. It's to the left, and on the other side of his house, it's also facing closer and facing his yard. And you can see that was taken from my bedroom upstairs, which also faces his yard. So it was a very minor modification. That's why the staff recommended, and they noted it. If you read their comments under their analysis, they said changes are modest and doesn't impact any neighbor. In fact, our immediate neighbors commended. They came by and they commended the way the house looked now, and said it added a lot of value and charm to the neighborhood.
Thank you. I'd ask you a question. I understand the reason for moving the window. The window was originally a block window. Is that correct?
Correct.
Was that for privacy?
I don't.
No.
We didn't really have any particular reason why it had to be block, and it was just we were putting together design, and as time went on, and particularly with the insistence of the plumber and so forth, we figured it would be good that we'd have to move the tub and the shower around. We'd have to move the window, and so in doing so, we figured it would be better even to have a window that was going to allow some ventilation in and some additional light, because on the second floor, on the side actually facing Mr. Feely's house, we have no windows up there, so it's all blank. And so we just wanted to move the window over a little bit so that it would fit over the tub. We made the window smaller, and the window is high up too inside of that wall. It's over 4 feet from the floor up, and it will give us, as we find, more light, which we need there, and also ventilation. And we don't see any harm at all to anybody in the neighborhood, including Mr. Feely.
And Mrs. Freshman, if I may add, please, if you look at the picture that's labeled number 6, that'll give you an idea. We moved it. It's moved over maybe 3 feet, if you can see, and it's smaller. And actually, it's away from his yard. You see less of his yard, if that's a concern. It's more to the neighbor next to him, which, if you see 8, 9, and 10, they have 2-bedroom windows right over his yard, if that's a concern.
If I could add one other thing, too, is there is no second-floor window on Mr. Feely's house. So,
no,
so
you
there's
can
really
look.
nothing. I mean, I don't understand what his problem is, quite frankly, but...
Okay, if you just, stick to the details and not get into the back and forth, please.
I apologize. But number 7, if you look at the picture 7, you can see Mr. Feely's house. His living areas are all towards Evergreen Street. And I'm a 65-year-old woman, and I'm certainly not going to be, if there's anybody that should be concerned about anybody looking in, it would be me, and I certainly have no issues with that.
Okay, thank you. Any questions for the applicant?
Yeah, I do.
Mr. Melnick.
Yeah, I have a vivid recollection of the other hearing we had and the issues and the presentations. And I was struck, and I understand about redoing the tub and the shower and the so forth, but I was struck just how much talk there was before about, I understood the block window is to compromise, with Mr. Feely. Yeah, his concerns about I think the words were used was looming. He thought it was looming over his yard, and that the block window was there, just so that there wouldn't be a sight view, of his house or yard, and I just thought the block window was a concession to him and his concerns. And so I was just struck, first of all, moving it's one thing, but making it not block, it just seems like it went against a lot of, what we were concerned about, what he mentioned. It just seemed like it was all part of the compromise. So would you be willing, just for the sake of argument, would you be willing to change it back to block?
I would, no, I'm coming in not to have the block because of, our thoughts as time went on, that given the structure of the internal part of the house and also the fact as it was being built, we could see that we definitely need some more light and we need some more ventilation. And to get to your point about a concession, there was no concession. Absolutely, there was no concession. I met with Mr. Feely. I tried to talk to him about what he would want, and I could not get out of him what he wanted. So as far as I'm concerned, the board never required it. That didn't discuss that this is something that had to be done, and so it was basically forgotten. I agree that there was some talk about it, but it was not approved by the board, and it was not part of any concession that I had with Mr. Feely. In fact, there really was no concession because he didn't want any of the things that I proposed, including the final proposal, which was approved by this board.
And if I may add, as you can see, we're beyond the pictures now. We contracted. We have a contractor who's putting our tile in for us around the shower and we have the plumbing in, and as you can see, it's just a very small window. It's a small window. It was just shifted to the right. It's smaller than it was. That's why the staff recommended that it was so modest, the changes, that it wouldn't impact anything. And as I said, the neighbors think it's very charming with the stone. It ties in very well. And it's very small. It's a small addition. It's like 11, 10, once it's finished, 9 by 18.
Madam Chair?
Mr. Owen.
I'd like to move to a slightly different topic, and if I may pose my question first to staff. I was confused about the discussion about the chimney. The chimney is larger now than it was depicted in the plans. The plans submitted reported or referred in many instances to existing chimney. The words existing chimney were repeatedly written on the plans, and the chimney appears to have been made taller. And what I'm confused by is making the chimney taller. Well, let me first ask the applicants, why did you make the chimney taller?
Well, this was part of the design. So what I'm saying here is that it was built, the addition was built, including there was an extension on the chimney.
Yes.
To be consistent with the design. That's what we had been told by the zoning office, that everything had to be consistent with the actual design.
It had to be compliant. It had to be 3 feet above the roof line.
Even though we didn't realize, I said that this wasn't a zoning issue, but we talked to them and they said, yeah, that it has to be consistent with design, and that's why you have to come in, even though you're moving your window a very small amount, you still have to come in and get approval. So that extension on the chimney is, if you take a look at it in the design, it's exactly consistent with the design. And it's also compliant with the code.
So to clarify, you made the chimney taller because the staff required you to. Is that your assertion?
No, it's also because that was what was on the design, and so we were trying to follow the design.
Okay. So now I'll turn to staff. Do you agree with that characterization?
Yeah, I mean, so basically, the main reason they're here is because of the condition language in the previous use permit. And it's actually in this one. It discusses shall be constructed in accordance with the footprint shown in the survey and the architectural drawings attached to the staff report. So any changes to the facade would be something that staff wouldn't have the authority to.
I'm sorry, that's not responsive to my question. My question is, what did the plans say? Did the plans call for the chimney to be changed, or did the plans call for the chimney not to be changed? It says existing chimney, right? Isn't the chimney still in its fireplace still where it was?
Yes, yes.
The question is, and there's no dispute that the chimney is taller than it was before this permit was first submitted. The chimney's taller now. The neighbor's complaining, why is the chimney taller than I thought it was going to be? We have the applicant saying, the staff made us make it taller because that's what was consistent with the plans, but what I read in the plans is existing chimney. So I'm very confused about whether or not the chimney has grown, and if so, was it proposed to grow? And if whether or not it was proposed to grow, has the staff required it to grow?
I am not certain, because Mr. Noxon actually drafted the staff report and spoke with them. I'm not sure what he saw.
Is the chimney, but we're not claiming it was a safety issue, right? That there's not a code requirement that the chimney has to be a certain height to keep the fire from burning the roof?
Well, I can tell you from personal experience, having put a second story on a one-story house, there are definitely rules about how tall the chimney has to be to clear the roof line. Right. Now, whether or not that was true in this case, whether the new roof line is the same as the old and wouldn't require an extension or not, but there are definitely the safety rules regarding the height of the chimney.
Yes, Ms. Freshman, Mr. Owen, it is. If you look at the new roof line, it is higher. So, and the code to be compliant, you have to be. It's 3 feet.
It's higher,
so
then
it has
they have
to be 3. So we had to comply.
It's an extension based on the new height.
Based on compliance,
Right,
yes.
yeah. I mean, you can't have sparks coming out of a chimney with structure all around it. So that's why the chimneys are up above the.
Okay,
It is 3 feet.
That's an answer I can live with. Thank you.
Okay, go ahead, Mr. Melnick.
What you were saying about the window, the window not being blocked, that it wasn't a concession, but from what I'm seeing from the report, it was part of the plan, and that's a deviation. And it's my understanding that that's part of the reason why we're here tonight, because it's a deviation from the plan as submitted. So it is important in that aspect, of course, and that's the thing that I'm most concerned about.
We did get it. We did go to the permit office. We talked to them about it, and they told us that we just submit the drawings. We did, and they approved it. So it was no problem. They said it's very common to do that.
Yeah. I guess the critical point here is that it doesn't make a difference. It really doesn't make a difference if there is a regular window or a block window. That window is not facing any second floor window or anything that is even close to Mr. Feely's house. In other words, there's a lot of benefit that we get, the ventilation, the light, and I think the appearance too, but there's no detrimental impact to Mr. Feely, for us, to have a regular window rather than one with blocks. I mean, I don't understand how that would be that much different, because someone could stand in front of a block window and you could still see the shadows and the outlines of the people.
Okay,
and,
let me interrupt you, because we're using a lot of time over a very small issue, only for me to say before I call the speakers that I raised the issue of the block window initially because I thought it was important, not just as a concession to moving it. I understand about construction issues, but I felt it was important that it remain a block window as well. So we can address that later, but if you would please take a seat, we have 4 speakers. The famous Thomas Feely, to be followed by Sharon Dorsey.
May I approach?
Thank you.
Thanks.
Thank you for the opportunity to be here. I am Tom Feely, and this is the 3rd time I've been here appearing before the board as primary affected owner on the Lot 10 property, whose rear yard faces this lot. In June 2015, we heard an approved but modified permit that included specific concessions to address board concerns and opposition concerns. In fact, if the revised statement of justification in the 2015 permit, number 7, states the obscure block window. I assumed that it was required to build according to the plan when this was approved. The staff report confirms that the exterior elevation and design was not in compliance. These changes are unfair from our perspective and injurious to our property. I'm merely asking the board to uphold the June 2015 terms that were agreed to. On the first page, you'll see that there are a few things that haven't been honored. Some of them you've discussed already. The rear obscure block stationary window is a big one for us in that location. The existing chimney, of course, was demonstrated but not preserved. The roof peak was also built far below the top of the chimney, not as represented. There's also concessions for a 7-foot fence or trees, and I have a question on lot coverage that I'd like to bring up with you. So basically, the obscure glass block window that you see in the plan was incorporated to address privacy concerns, and from our perspective, a key design element to gain approval at the June hearing. I'm asking the board to preserve this privacy feature for us. For Virginia code reference, there's no justifiable reason why the bathroom design cannot be achieved, and I've spoken to the county about that. I guess I expected the overall terms of the permit would be honored and not treated as an a la carte choice of what you prefer. Flipping to the second page, slide 2, this is not a modest addition, as you can see, for the lot constraints from our perspective. If you compare the plan to the as-built, including the unauthorized changes, the plan misrepresented the whole scale of the addition. Oops, sorry. If I can
Would you sum up, please? We can ask you questions.
Yes, okay. So it's even more imposing. I guess flipping quickly to slide 3, this is the observation of the difference between the plots
In 2015, there was a requirement to remove part of the driveway for 40% lot coverage. You'll see that in the September 16 application, that's completely gone. So I don't know, per observation, the driveway hasn't been adjusted, but I'm not sure whether that goes away with this permit or not. Just to sum up quick, and thank you for that, on slide 4, it's just a brief look at the benefits and the detriments from our perspective. The UP3 really doesn't achieve a balance of fairness for us, and it retracts agreements and concessions that were put forth. So the June 2015 permit already provided many courtesies to the setback. So the applicant effectively agreed to abide by the terms and then ignored some of them. So these liberties that were taken really just contribute to the imposing structure and amplify our need to have a privacy window as part of the design. So basically, they got everything they desired at the expense of our property. All I'm asking for is the board to uphold the permit and preserve the stationary window for us to deny UP3. Thank you.
Thank you. Sharon Dorsey.
Hi, my name is Sharon Dorsey, Madam Chairman, members of the board. I'm here as one of the over 40 neighbors who submitted letters opposing the initial use permit that was submitted to you in June of 2015. I respectfully ask for your help in really understanding this process and why we're all here today. In June, the board approved the use permit with specific design considerations. Those concessions that were just identified by Mr. Feely have not been complied with and is in direct conflict with the intention of your June 2015 decision. That is to provide privacy for the neighboring property for the reduction in setback. I ask that you uphold your original decision and direct compliance to the use permit. I also ask you preserve the original privacy features in the June 2015 use permit by denying this request. Thank you.
Thank you. James Ching Lee.
Hi, good evening. My name is James Ching Lee. I'm also a neighbor of Tom Feely's. I can see the extension from my house. I'm two doors down. I have an interest here as a concerned neighbor, both from a privacy standpoint and from the permitting process. We were here last year to discuss on the privacy standpoint, and there were definitely concessions made in terms of the design, including trees, fencing, and that block window, and that seems to be a new issue now. From a permitting standpoint, it looks like it's a case of begging for forgiveness instead of asking for permission. The window's already there. They already put in the new window. They are on their way to finishing the addition. The county's already cited them for noncompliance. I'm here to know just what is this process? Do you build first and then request permits afterward? We look, as a homeowner too, we look for these kind of issues because it's something into our consideration for the future. So, for now, I would like to request denying, the new permit and upholding what they submitted last year. Thank you.
Thank you. Thank you. And the last speaker is Rochester Johnson.
Good evening. My name is Rochester Johnson. My wife and I purchased the property at 5000 Washington Boulevard and have lived there continuously since 1995. This property shares a lot line with the applicants. On Friday, September 9th, I received a letter from Arlington County regarding this hearing dated August 25th. It was not postmarked until September 7th. The applicant's immediate neighbor has never received the letter. No notice regarding this hearing was posted in the neighborhood until Friday. Just wanted to point that out to you. On June 10th, 2015, a use permit was granted regarding the property at 5010 Washington Boulevard. Nearly 40 neighborhood homeowners signed a document in opposition. I was one of those who signed in opposition, primarily because I believe the property was already overbuilt, including the addition of a driveway that causes water runoff that environmentally and economically affects not only me, but also my immediate neighbors. By contrast, in the application for the June 10th hearing, only one neighbor signed a document in support. Note, I said neighbor. A review of Arlington County records reveals that this neighbor was not an owner of the property she attested to. As for the property at 5010 Washington Boulevard, many of the last 20 years it has either been empty or a rental property and not a residence for the applicants. The disclosure statement to the pending application even states their address as being Florida, and they have in fact cars with Florida's license plates. At least one of these cars has been continuously parked in Arlington County since June 15, 2015. A raised deck was put on the back of the house that looks to the immediate neighbor's primary living area. To the naked eye, this deck appears to be extremely close to the lot lines on either side of the house, potentially inside the distance allowed by Arlington County. As I stated earlier, a large portion of the front yard was turned into a semicircle driveway with the additional side parking. No permit for either project can be found by county staff in the permit office on the 10th floor or environmental services on the 8th floor of this building.
Could you sum up, please?
Yes. According to both offices, all permits or requests thereof in the Arlington County system pertain to this far from completion addition to the property at 5010. Precedent has already been made in this matter with regard to granting of the use permit, precedent that has potential to affect not only others in Arlington County, but also the makeup of Arlington in general. If this application is approved, additional precedent will be made, and the message this board in Arlington County will appear to be sending is ignore the BZA, build first, seek approval later. Based on the prior history of actions taken at this property and to avoid setting additional precedent, I hope the board denies this application and simply holds the applicants to any and all that was approved in June of 2015.
Thank you.
Thank you.
Comments, questions?
Madam Chair, I
Mr.
have
Smith.
a question of staff. What is the status of the driveway? Was that removed? The page 3 of Mr. Feely's submission, you see that? It seems like the left side was circular, that was to be reduced.
Would you care to answer that, homeowner?
And did you see what the Feely's, what Mr. Feely had prepared?
Yes, I saw that, and, okay, and there was a variance and a use.
Is the picture on the right accurate?
On the right of the
of these two, the one on the left is let's say dated 2015. The one on the right 2016. The one on the left shows a circular driveway. The one on the right, September 2016, seems to show it having been eliminated. Is that the case?
The circular driveway wasn't eliminated.
Okay.
No, it was. There's a piece of about 4 feet. As I said, there was a variance and a use. Okay, the variance had to do with 40% coverage.
Right.
Okay, we asked for 41%, and then we were asked, well, would you just keep it to 40? I said, I'd be glad to keep it to 40 and cut out part of that driveway, about 4 feet. It's like part of a little pad. So that is going to be cut out.
Oh, it hasn't been, though?
It hasn't been, no, because we haven't finished. I mean, we've been working on this for like 2 years now, and
that's the answer.
We're not finished yet.
That's the answer.
Yes.
Thank you.
Thank you.
Sure. Okay.
Other comments and questions?
Yeah, could I make a slight rebuttal as to a statement that was made relating to a citation?
Briefly, please.
Statement that was made
Briefly.
against me, and I certainly obviously don't appreciate when people say things that are incorrect, especially when they don't know the information.
Okay, if you would make,
You are not
excuse
cited
me,
by the zoning.
excuse me. If you would make your rebuttal without a lot of embellishment, that would help. I hear there's a lot of people here who are still waiting for their cases to be heard, so I'm trying to keep things moving efficiently and not have repetition.
fine. I just wanted to say that there was no citation. We were told that it would be good to go, if we wanted to make the change, to go to the zoning board and file, which we did. And we're not told to cease or desist or anything. And we just proceeded like we thought we should. And in fact, the design was totally approved, and we have proof of that by the building department.
Thank you. Other questions or comments?
Yeah, I'd
Mr.
like to
Melnick.
Okay. I'm leaning toward sticking with the June 2015 approval that we made. It does, and it just seems like, we worked very hard on that approval and coming up with the plan and how it was submitted. And it is disconcerting, things switching around and actually being built, prior to us being here. And so that's just my thought.
Thank you. Other comments?
Madam Chair, just to follow up, with respect to the chimney, I don't have a problem with that, but the window I do.
I as well.
So
Yeah,
with
I'm in agreement.
Mr. Melnick on the window.
I agree as well. No. Please sit down. Please sit down. We're now in the process of discussing. Thank you. Further comments? You ready for a motion?
Madam Chair, let me try a motion.
Okay.
I move that the Board of Zoning Appeals adopt the attached resolution granting use permit V-10995-15-UP3 for the increased height of the chimney, but denying with respect to the window. And then, of course, and then all of that would be subject to the conditions which are listed in the resolution.
Madam Chair, I have a point of clarification on the...
Mr. Owen.
I don't think that's been applied for. I don't think the chimney's been applied for. It does not appear to me that the chimney has been applied for.
Well, then it's been an outright denial. I move to deny V-10 995-15-UP3.
If I could clarify, it looks like that is. Oh, can I be recognized?
Please, Mr. Melnick.
Okay, it looks like that was most certainly mentioned by the staff as part of the non-compliance of the previous plan. That's what I'd like to bring up. That's why I thought, it was okay to mention it. That's it's on that sheet right here where it lists the deviations. So that's why I thought that was okay. Do you have a position on that?
Yes, I would ask staff. I mean, what I read here on the copy of the application dated June 16th, I don't see a mention of the chimney. I see it's only about the windows. So I see no mention.
Well, the application is for to amend, and then this Appendix A, June 15th, cites two deviations. One is the window and the other is the chimney. So the application itself is to amend without detail.
That's an exhibit provided by Mr. Feely. That's not something that was provided by staff.
Oh, okay.
Moreover, the statement of justification from the applicant does not address the chimney. So I think that was all brought up by Mr. Field.
The amendment is only addressing the window, which has moved and been changed in material.
Okay, that's fine.
Okay. So how does that change? How does that change?
It wasn't
The
necessary.
amendment.
But it doesn't change my, the substance of my motion, which is to deny the present condition of the window not being in conformity with the June.
Are you talking about the placement or the material or both?
Really both, but the material more than the placement.
Okay.
So I would, I guess, by way of discussion, I would allow the window where it is, but that it has to be block, glass block.
Okay, so that's clear. We're talking about an approval of an amendment accepting the new location of the window, but not the materials. So that the original approval was for a block window in a certain location. It's now in a different location but needs to remain block. No.
So just to clarify, Madam Chair, I think what it sounds like happened in the last minute was some discussion, but I'm not sure what the motion, if there's been a motion. Okay.
I'm going to try to reform it.
Okay.
So I'm sorry, I just move unanimous consent to withdraw all motions that may have been in the record to this point.
So ordered.
I don't think any were seconded, though.
No, but that's okay.
You have my consent.
Someone begin again.
Okay. Paul.
All right, so,
No chimneys.
pardon?
No chimneys.
Okay, so in case V1099515 UP3, I move that the Board of Zoning Appeals approve the resolution allowing the change of location of the subject window, but requiring it to be in size, and requiring it to be of the glass block construction as was approved in June 2015.
Second.
Moved by Mr. Melnick, seconded by Mr. Smith. All those in favor?
Aye.
Aye. Opposed?
Madam Chair, I was going to speak to the motion before we voted.
Sorry. Go ahead. We'll vote again.
Thank you, Madam Chair. I just wanted to say briefly that I was not on the board during the previous consideration. So during the weekend, I did. First of all, I would like to mention that when I visited the site on Sunday, I did not see any signs on the utility poles for this BZA meeting, and that surprised me. So I just want to ratify the concern that the neighbor had made about perhaps the notices were not placed. I don't know if other BZA members observed that. Secondly, I did take the occasion, since I had not been on the board, to go ahead and review the audio for both of the previous hearings. So I have a sense for the frustration that everybody who was there, must feel at this point. It sounded like the conversations about this have been very hard for everyone involved, both the applicant and the neighbors. So I'm very sympathetic to all of that. But in listening to the hearing, there was no question that, in my mind, that Mr. Sujat specifically mentioned at the meeting where he obtained his approval that he was offering the block glass as one of an explicit list of concessions in order to obtain approval. And it was both in writing and the written materials and in the verbal presentation. So I came away just as an impartial observer who lacked the emotional, trauma of whatever was going on. It just seemed objectively to me that that was clearly part of the deal that was being made. And I appreciate that this was a further challenge, because oftentimes we ask neighbors to talk with applicants and to reach their own deal, and then we just ratify that deal, and that allows us to go back to the neighbors again if there needs to be changes. Here that didn't happen, and so the deal was sort of with the BZA itself, acting in sort of the shoes of reasonableness, and so I just want to offer those observations that as a sanity check to anybody who was wondering. I know some of the neighbors said, "Are we crazy to think that this, to think along these lines?" I don't think don't think that's crazy. I do appreciate the Sujats as well. It's clear that parts of this process seem confusing to a lot of people and may have seemed confusing to them as well. So that's clearly contributing as well. I don't think that the Sujats are necessarily operating in bad faith and trying to get away with things, but it's also clear that they perhaps at times don't fully understand the process and the precedents that we set and the meaning of some of the things that happen. So just want to offer those thoughts.
Thank you. Can we? No, sir. Okay, we have a motion on the table. Does everybody understand the motion?
Yes.
Okay. All those in favor?
Aye.
Aye. Opposed? Thank you. Next case, please. Mr. Owen.
As to the next case, I have a long-standing professional acquaintanceship with the next-door neighbor, and so I will be voting present only, and I will not participate in the discussion.
Thank you.
The next case is V-11176-16-UP-1. It is a use permit request by Stephen Antosh, owner, to permit a setback of 3.5 feet from the left side property line instead of 8 feet as required to maintain an existing grill structure in the left side yard. The property is zoned R5. The premises is known as 3215 First Street North. The staff recommendation is to adopt the attached resolution granting the subject use permit with conditions.
Thank you. Questions of staff? We hear from the applicant, please.
Evening. My name is Steve Antosh. I'm the owner at 3215. Happy to answer any questions that you all have. I've provided the pictures. I have provided support from 3 of the neighbors, no objection from 3 of the neighbors. I'm committed to keeping the grill completely screened. None of the neighbors can see the grill. There's a fence on one side, and then there's landscaping around the other side. So happy to answer any questions.
Thank you. Questions of the applicant? We have speakers? No. We do have 2 letters that have submitted to us. Considering no objection. Okay. It's your pleasure.
I'd like to make a motion.
Please, Mr. Melnick.
Okay, in case V1117616UP1, I move that the Board of Zoning Appeals approve the resolution granting the subject use permit as shown in the staff report with the conditions as listed.
Second.
Moved by Mr. Melnick, seconded by Mr. Smith. All those in favor? Aye. Aye.
Present.
And 1 present. Thank you.
Thank you.
Next case.
Next case is a variance request by Arlington County Transit property owner to permit a fence with a height of 8 feet instead of 7 feet as permitted within the street, sides, and rear setbacks, and a variance to waive the requirement for a landscape plan and the landscaping requirements for a parking lot. Regarding the use of an existing parking lot to park Arlington County Transit, ART bus vehicles, and associated equipment, the property is located in the M1 zoning district at the premises known as 2629 and 2631 Shirlington Road.
Was this not withdrawn?
A portion of the request was withdrawn, so the fence request is still being made. The request to waive the landscaping requirements has been withdrawn.
Good. That was an issue. Okay. May we hear from the applicant, please?
I'm Steve Yaffe, Transit Services Manager, and I'll be brief. The county has leased this property at 2629 and 2631 Shirlington Road for the purpose of parking ART buses. And we have respectively requested to withdraw our variance request for the landscape requirements, so we'll be complying with that. But we are requesting the variance to erect an 8-foot-tall fence as a security measure to protect these county assets. ART buses, several ART buses have been federally funded. We are following guidance from the Federal Transit Administration and the Transportation Security Agency, which is part of Homeland Security, on how to secure transit facilities. As part of the TSA regimen, we've been asked to complete a threat vulnerability assessment, which we did in 2014. And that study is the basis for the Shirlington design specifications and our request for that 8-foot-tall fence. Denial would create a security concern for us, for the art fleet. Each bus that would be parked there costs more than $500,000. And in these days where we hear news from Europe of a disconcerting nature and the Middle East and Asia, security is a prime concern. Thank you.
Questions for the applicant?
Madam Chair, I think I have to disclose, though I don't have a connection to Arlington County Rapid Transit per se, or the county contracts with a private contractor and those for the provision of the bus service, and I'm the representative of the drivers. They're in a collective bargaining relationship with that private company, and I'm their representative as a lawyer. But I don't think that impacts my ability to be fair and to be impartial in hearing this case, so I won't recuse myself.
Thank you. Other questions?
Madam
No?
Chair.
We do have a speaker.
Oh,
Lest you be ready to move ahead.
I'll wait for the speaker.
Okay, go ahead. Michael Greavy? Okay.
Thank you. Hi, my name is Mike Graney. I'm the manager for Columbia Real Estate Investment Group, who owns the property adjacent to the proposed bus storage lot and is most affected by the variance request to erect an 8-foot fence topped with barbed wire. We strongly oppose this request. 3 issues. First one is timing. Our public notice as the adjacent owner is dated August 25th, 2016, which we received on Monday, September 12th through the regular mail. Yesterday, I was able to get a copy of the submitted application to the county office, and now I'm here tonight attending the meeting. This is the first that we have heard of it. I'm sure that everything was done according to county regulations as far as public notice, but because of the direct impact on our property, it would have been appreciated if what was proposed was brought to our attention sooner. Maybe have asked us as our concerns or input or how best we could have worked together. What you decide here tonight, we have to live with as neighbors working together over the next 7 years, which is the initial term of the proposed lease with our Arlington bus. Direct impact. DC Rentals is a tenant that occupies a building directly adjacent to the storage lot. Over the years, they have spent a lot of money improving their space with corporate offices and showrooms. They have clients and customers who frequent this space on a daily basis. They have worked hard to improve this industrial area and feel that erecting an 8-foot fence topped with barbed wire will be a big step backwards in improving the aesthetics of the neighborhood. County to county, it seems a little disingenuous for Arlington County to request a variance for another county's use to create a prison-like compound and to ask the landscaping requirements waived as well. I guess that's an update, but the county has made tremendous progress in improving this industrial district with sidewalk, bikes, lanes, plantings, and now wants to give a variance to another division, which seems to be a reversal of what they've been pushing for many years. We do understand that a bus storage lot is permitted use in M1 zoning. However, as the adjacent property owner most affected by the variance, we're asking you to postpone this decision tonight because of the 3 issues I just mentioned. Timing. No one from the county asked for our input. We do understand maybe they don't need it, but it would have been nice if we could work together on a plan that benefits all parties, so a little more time is needed. Direct impact. I welcome the chance.
Sir, please sum up.
I welcome the chance to walk through DC Reynolds' corporate office showroom with the Arlington County Transit personnel so they can see firsthand what impact having an 8-foot barbed wire fence adjacent to the parking lot would have. And finally, we're not opposing the use. We understand it's a permitted use. We do recognize the safety requirements for secured location for these buses and the impact it can have on federal and state funds. But we would like to work together to come up with a viable solution. We feel that you giving the variance tonight will not allow us to give adequate input to the final product.
Thank you.
Thank you.
Questions, comments? Mr. Owen.
Well, my question was going to be to the county. I'm sorry, sir, I forgot. I didn't catch your name.
Steve Yaffe.
Say again?
Steve Yaffe.
Steve, what's your last name? Gaff?
Yaffe.
Yaffe.
With a Y.
Mr. Yaffe, I'm sorry. I saw Mr. Leach's signature all over the application, so
Okay.
I wasn't sure whether I should expect him. But Mr. Yaffe, did the zoning office advise you that it is typically the practice of the Board of Zoning Appeals to seek for applicants to contact their abutting neighbors and get their views and submit them to the board?
I would not have been the first one to hear about it. I'm not the one who filed it, so I can't answer that.
Okay. Thank you. That's my question.
Yes, notification of is generally an issue, I think, more than it used to be, appears to be. Go ahead.
Yeah, I have a question for staff. This is, at least the second time this sort of issue's come up with parking lots in the county and the requirements for security, in the CPTED, the 8-foot tall fence and that kind of thing.
Eads Road facility, same thing.
Eads Street, same thing.
Yeah, exactly. And has there been any, it just seems to me that there ought to be a proposal to the county board to modify this, because it seems like we're kind of putting a square peg in a round hole, trying, with this whole variance thing, because even the staff admits there's not a hardship. It's more like, well, this is a federal guideline, therefore, let's just do it. It seems that way. So it troubles me a little bit that it's been called a variance when there's supposed to be a hardship.
Right.
And this, could be used for other parking. It seems like there could be other ways of having security. But I don't know, I'm just troubled that it's being, put under the rubric of the variance. And I understand about security, but it seems strange to me that somehow there's a hardship analysis here, based on, these guidelines, when even the staff is saying there's not a hardship. So that's, it troubles me, although I understand it. And I don't know if there's any other way to try to make this happen, but are you aware of anything with the county board trying to fix this so it doesn't have to be a variance when this issue comes up?
I'm not aware of any other proposal. I think, no, I'm not aware of any other proposal to try and address it. I think the hope is that we don't have to, that we find a location that works. I mean, the Each Street facilities where this was supposed to happen, and so this is basically a change to move those buses to this location. I think the county would be happy to find a location where this could be permanent and we don't have to go through this many more times.
Actually, that brings to mind a question I have then. So did this board previously consider a variance for the East Street location?
Yes.
Yes.
Did you approve it?
Yes.
Yes.
But it's not going to be used?
Not for the buses.
Though.
It's going to be used for something.
But so, just out of curiosity, was that approval, did that have a time limit or any condition that would make it expire if it wasn't actually going to be used that way?
No.
I don't think so.
May I clarify?
Yes.
We have 65 buses. We'll be growing to 85 buses as part of the just approved 10-year transit development plan. EADS can hold at best 45, and once we are able to move in, I suspect it will be less. So rather than have homeless buses, that's why this facility was leased. And I agree, certainly, I wish it was a permanent solution and not a 7-year lease. EADS does have the tall fence, it does not have barbed wire.
Right.
Well, my point is that this has come up on other applications I've made this point. This is a permanent solution to a temporary problem. For all time, we would have a variance potentially for this tall fence, even if the county 3 years later moved away. The tall fence would be permitted by variance, for years afterwards. So even if I were inclined to approve this at some point, which will definitely not be tonight, I would want to have a time limit provision or a contingency that it be so long as the county controls the property or something like that. And I'm just making this point in general for all variances because the General Assembly in 2015 did change the variance law. And so and then we have situations like federal regulations or The ADA has been brought up in the past, and so if we have these extrinsic non-hardship related things that relate to the activity that's going on the property, I think that we have this explicit statutory authority to have the variance expire, and we should exercise it. And so I think it's a perfect example of where we should do that.
I'd agree with you, Mr. Owen. That's absolutely.
And so the other thing I would say is, I'm sorry, thank you very much for responding. The other thing I would say is I'm prepared to defer this as we would for any other application where the neighbors clearly had not gotten the appropriate outreach. That's the minimum. I probably would support, if someone else were making it, a motion for outright denial, because I'm very sympathetic to the notion that the county board has the power to rezone, to change the zoning terms, to make industrial zoning allow 8-foot tall fences. That would not be an unreasonable thing. And I'm who could be the least sympathetic applicant? You know, the one applicant who gets those for free from their own boss. You know, so I'm just a little surprised.
Free. They paid $3,517.
Yeah, from this hand to that hand. So, so anyway, I just wanted, in case my colleagues are ready to make motions, I just wanted to put my thoughts out there.
Other comments? Provocative. I'm glad that they're still going to landscape it. I'm sympathetic to Mr. Owen's issue, though, about the fact that we do seem to be, this doesn't seem to be a variance. Maybe that's the only vehicle for dealing with this at the moment, but it doesn't really seem appropriate. And particularly on a site that the county doesn't own. I think they own Ead Street. But if this is just a lease, that to me is a temporary use. And why wouldn't, at the very least, the fence go away?
And just in case it's not perfectly clear, I think I'm not opposed as a citizen to having buses go here, and I'm not opposed as a citizen to the 8-foot tall fence exactly as proposed. It might very well be good public policy, and I'm not disputing that. I'm just saying, is the BZA the right venue to get that through?
Apart from the notice issue.
Perhaps we ought to ask what he thinks about a deferral.
Mr. Yaffe, what do you think about a deferral for everyone to come together and talk this over, given the issues that have been raised tonight? I assume, like most things, everything is time sensitive, but nevertheless, it's an important issue.
I'm more bothered by the deferral than the idea of attaching it to the length that the county controls the lot. That actually makes a lot of sense to me. We are under pressure from the NOC community, who we did discuss this proposal with, to hurry and bring buses out of the LaPorte lot to Shirlington and Eads. And Eads isn't going to be ready for quite a while. So I think we have to make sure that there's a decent fence that's functional around the perimeter of the property as soon as possible, and we'd rather spend the money once than twice. The current fence is actually owned by the people that Mr. Graney is representing. It's dilapidated, frankly. And the sooner we can put up a good, secure fence, the greater the comfort level.
Okay, what's your
Madam
pleasure?
Chair,
Mr. Smith.
Mr. Yaffe, you're referring to the fence we see in front of us that you called dilapidated? Okay.
Yeah.
Thank you.
don't know. Nothing happens, yeah, but we have to do something. We should do something.
We don't even know how long you'd want a deferral for.
Because I think practically nobody's offering any other option like the board. So,
I know, and I wonder how long a rezoning would take.
well, starting with advertising, easily 4, 5, 6 months. Mr. Smith?
Well, Madam Chair, I guess it falls to me.
Thank you.
Hearing having no one else wishing to make the motion to defer, I move to defer V-11177-16-VA-1 to the October meeting of the Board of Zoning Appeals.
With direction?
Oh,
They ought to talk to the neighbors and get some feedback.
and as well, talk to the county manager and board and see if they would entertain a zoning change. The county needs places to put its buses. The buses need a fence. There needs to be some place in the county to do that. It appears that possibly there's no place in the county to do that, and we can't have buses. That's not a good outcome. And if it's not appropriate for the BZA to do variances, I'm sorry, am I speaking out of turn?
I just was looking for a second.
Second.
Thank you.
Mr. Owen did second, I heard that. And Mr. Yaffe, I think Mr. Leach is the applicant. I
Yes.
think we have to have Mr. Leach or
Let's have Mr.
someone
Leach
from the
next
county
time.
attorney's office, or, I think they put you in a untenable position.
I'm in agreement with everything that's been said.
Please carry those comments back. Thank you. Moved by Mr. Smith, seconded by Mr. Owen. All those in favor?
Aye.
Deferral to October. Thank you. Next case, please. Lordy, lordy.
-11178-16-UP-1, a use permit request by Cynthia Ludstrom to permit a setback of 6.4 feet from the left side property line instead of 8 feet as required for a new 1.5-story rear addition in the R6 zoning district on premises known as 1638 North Abingdon Street. Staff recommendation for this request is to approve the attached resolution approving the use permit.
Thank you. Questions? Hear from the applicant, please. Cynthia Lundstrom.
Yes, I'm Cynthia Lundstrom, the homeowner. I'm here to answer any questions that you might have.
Thank you. Any questions for the applicant?
I have one.
Yes.
Where are the statements of support or opposition?
That was not required. I did talk to my neighbors, and they said they were perfectly fine with my building and my building plan, but I was told that that was optional.
Okay. Let's pause right here to talk about the application and the mention and the chair's note, which was written with the intention of being given to applicants to stress the importance of talking to neighbors and submitting information at least a week in advance so that we get it in our packet. So where are we?
And Madam Chair, if I can join you, I know that we have a new zoning administrator, a new acting, but this has been a recurring kind of issue with us for years, really, and something that we obviously require. We seek to hear from neighbors. We seek to know really whether they've been contacted and shown plans. And I appreciate your representation, but I don't know if you were here earlier when you heard Mr. Owen asking specifically about the neighbor to the right, the neighbor to the left, the neighbor to the rear. And they're most immediately impacted by changes, and this is not really a minor one.
The posting was put in my neighbor.
It's talking.
Yeah, excuse me.
And that's the kind of thing that we really look forward to seeing, because people who are immediately adjacent are directly affected. And I appreciate your representation that you talked to them, but that you didn't believe that it was optional is kind of disturbing, because we really want applicants to be impressed with the need to do that kind of reach out. It's not blaming you, but you should have known that was something that we really look forward to seeing.
Well, and that's what's come up time and again, and that's why and there have been times when issues that we thought perhaps were controversial have actually been deferred solely on the basis of the fact that we didn't have any input from the neighbors. And that's why, in response to repeated issues like this, I had actually drafted something and asked that the staff give it to applicants, so that maybe it's just a little box on the application that's overlooked, but it needs to be stressed more, because it's a recurring issue on this agenda and as well as others. So that's an editorial comment that we can't undo unless we chose to defer it. But at least for the staff, please make note of that. And if you need another copy of my note, I can recreate it.
Madam Chair,
Mr. Owen.
I just want to further reinforce your comments, with which I'm in total agreement. And I would add further that I think applicants are very disturbed by any confusion on this point. We've had, just the county itself apparently had confusion about our expectations. And here we have another applicant. I regret that here you are, you've waited here all night, you've spent these months, you filed your application fee, and then to come here and be in any way surprised by what our expectation is, I feel that's a disservice to you as an applicant. That's not really fair treatment, and that's a shame.
And if I can make another point, that we've had a couple issues this evening about what is apparently unacceptably late notice of both to neighborhood outreach from the county and posting. And so, at least in the case of an applicant seeking feedback from neighbors, even if the county's notice is going to be derelict, at least the applicant has gone out and approached the neighbors and given them a heads up, because by the time they get it posted, they may not be able to even attend. So it's all of a piece of trying to be inclusive and make sure that by the time people do sit through all of this and finally get their day in court, that they have a reasonable expectation that they're not going to run into some kind of a surprise. That said, yes, let's go forward.
For this particular application, I think this case provides an excellent illustration of why neighbor comments are so important, because, and please correct me if I'm mistaken, but it appears to me that your next door neighbor has some windows that are very close to where this addition that you're seeking approval for would be built. Is that right? Yeah. So that's a situation where, as we saw in a previous application, that the windows and facing other windows and privacy can be a very contentious and important issue for us. And having that neighbor sign off that we can see and know that is there. I mean, the bind we would be in is, what if we get a letter the day after the hearing saying, I never heard about this, and this is outrageous, and I want to appeal to the circuit court or whatever. And then we lack confidence that we've exercised due diligence. And so in some cases, not having neighbor input, I feel like, we can let it slide this time, because how would the neighbor really be impacted anyway? But in this one, I think it's really tough, because the neighbor they're both very close to the lot line. the neighbor has a window in this location. I believe you're also proposing a window in the addition facing towards the neighbor. Is that right?
So one of the windows in the bedroom is going to be bricked up, and that's on their side of the house. The extension, the 3.9 feet of extension, will have two small side windows and a double window in the back facing my garage. So
Main window would not face directly to the neighbor, but to your own backyard.
my garage,
Right. But there would be an additional small side window that faces the neighbors.
yes, to help with airflow for that bedroom. But we're taking a normal size Arlington window, locking it up, and replacing it with a smaller size window in the 3.9 extension that's being built out.
Do you know what kind of room in your neighbor's house uses the window that faces where the addition would go?
Yeah, that's their kitchen.
Okay. And have you talked to, in your conversations with your neighbor, did the topic of the view out their kitchen window come up specifically?
Yes, my neighbor is Jim O'Brien. He's an architect. I've lived in my house since 1991. Jim and Susan have lived in their house longer than I have, as well as Karen and Al Leeds, which are on the other side. I've spoken to both of them about this extension, what I'm doing, and shown them drawings, just initial drawings.
Do you think there's any, based on your conversations with your neighbor, is there any doubt in your mind that they have a complete understanding of how the view out their kitchen window would change?
No doubt at all.
Thank you. Sorry. And further, that they have no objection.
They have no objection.
Thank you.
No.
Okay, I'm prepared to make a motion. I'd like to make a statement, and I agree with everything all the other board members have up here, about notice and everything. But you appear very sincere, and you have talked to your neighbor as you described, and we are working diligently on the process of notice and so forth. But I'm satisfied, just from what I've seen, the nature of this, that I'm prepared to make a motion for approval. So I'll go ahead and make the motion. So in V1117816 UP1, I'd like to make a motion that the Board of Zoning Appeals approve the resolution approving the use permit as advertised with the conditions as stated.
Second.
Moved by Mr. Melnick, seconded by Mr. Owen. Comments? Hearing none. All those in favor? Aye. Opposed? Thank you.
Thank you.
Next case.
I'm sorry, I just want to further add.
Yes.
That I really, really hope that we don't have to be in that kind of bind ever again on a case. I think that's a very uncomfortable position for us to be in as the BZA, to have to rely solely on, this kind of statement from a, from a party who's interested. And, the BZA does have the power to swear in witnesses and make them subject to perjury, and that seems not to be the practice for this. But, if we don't have the groundwork laid for being able to get accurate information, maybe we would have to consider such extreme tools in order to get the information. I just really think that's not the right way to run a railroad. And so because we got to this point, I really hope that no one gets the message that, oh, okay, we can do this in the future this way, because I won't necessarily want to have the same kind of procedure in the future.
Well, I hope at least two things, one of which is that our comments have been heard by the staff, and that it will be stressed at the time of application, including the chair's statement for emphasis. And my other hope is that it won't be misunderstood by the public at large, because we have in the past deferred solely on the basis of no feedback from neighbors, and we can do it every single time if we have to, which is a foolish waste of everyone's time and resources. But the point needs to be made.
Madam Chair, let me make one point also, that we're creatures of the circuit court, really the state. We're not creatures of Arlington County. The county board didn't appoint us. We don't report to them. We're not accountable to them. We are accountable to really the law as appointees of the circuit court in a quasi-judicial process. So we are asking people who we don't have authority to direct to do something that would make our lives and our role as board members easier. And it would also make it, as Ms. Lundstrom, I think, kind of evidenced, it would make it easier on the applicants, too.
Thank you. Next case, please.
V-11179-16-UP-1 is a use permit request by Phil and Nancy Harlan to permit a setback of 1.6 feet from the left side property line instead of 21 feet as required, and 16.1 feet from the rear property line instead of 21 feet as required. This is regarding a low-level rear deck with stairs on a pipe stem lot in the R6 zoning district on premises known as 1200 North Quantico Street. Staff recommendation is to approve this request.
Thank you. Questions? Hear from the applicant, please. Thank you.
Good evening.
Evening.
My name is John Fritch. I'm with JAF Design Studio. I'm here representing Phil and Nancy Harlan, who are here as well tonight. This application is for, as described, a low-level deck in a very interesting grading situation at the back of this property. There is an approximately 6-foot-tall retaining wall surrounding the back of this property, as you can see in the image. The desire is to utilize this space, which has never really been utilized. The proposal is for a deck that will be at the finished elevation of the interior ground floor. That will put the deck at approximately 4.5 feet below the actual grade of the property. However, it will be approximately 2 feet above the finished grade immediately adjacent to the house at that location. So technically it's above grade. Technically, it's still below grade. So it's a strange scenario.
It's built in a hole.
It's pretty late in the evening for that kind of jujitsu.
It's a very large window well that we're putting a deck in, basically.
Do we have any speakers on this item?
Yes, we have two. Okay. All right, questions of the applicant's representative? No, hearing none. Two speakers, Timothy Baxter.
Hi, my name is Timothy Baxter. I live at 1202 North Quantico, which is immediately down the pipe stem from the Harlan's house. And I'm in favor of that addition. It's as described by the architect. And I don't see it causing any problems with any of the neighbors, since about only the Harlans will be able to see it from their dining room door. So that's all I have to say.
Great. Thank you very much. Thanks for your patience. Teresa Bozo?
Good evening. I'm Teresa Bozzo. I live on the, if you're facing the Harlan's home, I live on the left side. And I'm on the left side of the White House. I'm in favor of the deck project. It will have no negative impact. I think it'll be a great use of their property, so they'll be able to utilize their backyard. And I believe it'll have a positive impact on their drainage in their back as well.
Thank you. Question? Mr. Owen.
Madam Chair, I think this is the easiest case of the night. I move in case V-11179-16-UP-1 to adopt the attached resolution granting the subject use permit with conditions.
Second.
Moved by Mr. Owen, seconded by Mr. Melnick. All those in favor?
Aye.
Thank you. Next case, please.
Madam Chair,
Mr. Owen.
with respect to the next case, V-11180-16-UP1, I am once again, oddly enough, have a long-standing professional relationship with the next-door neighbor, and so once again, I will not participate in the discussion and vote present.
Thank you. Hear from the applicant? Oh, never mind. You call it.
V-11180-16-UP-1 is a use permit request by Jennifer and Jerry Schweer to permit a setback of 16.6 feet to the eave and 16.9 feet to the porch base from the North Lebanon Street right-of-way instead of 21 feet as required. This is regarding a new front porch in the R6 zoning district on premises known as 916 North Lebanon Street. The staff recommendation is to approve this request.
Thank you. Questions of the staff? We hear from the applicant, please.
I'm one of the owners of the house on 916. Jerry Schweer is my last name, or first and last name. It's been a long night. I'll free to answer any questions that you have. It's just replacing an existing rotting out porch with a new, larger porch.
Got it. Any questions of the applicant? Any speakers?
No.
No, thank you. Okay.
Madam Chair?
Mr. Smith.
In the case of V-11180-16-UP1, I move that the Board of Zoning Appeals adopt the attached resolution granting subject use permit, subject to the conditions which are listed in the staff report.
Thank you. Moved by Mr. Smith, seconded by Mr. Melnick. All those in favor? Aye.
Present.
Thank you. Thank you for your patience. Next case, please. Oh, yeah, I remember
V-11181-16-UP-1 is a use permit request by Christopher and Tracy Shiplet to permit a setback of 7.5 feet from the left side property line instead of 10 feet as required, and an aggregate side yard of 16.1 feet instead of 18 as required. This is regarding a new one-story left side garage addition in the R6 zoning district and on premises known as 2109 North Kentucky Street.
Thank you.
Our recommendation is to approve this request.
Thank you. Questions for staff? Hear from the applicant, please.
Good evening. My name is Chris Shiplet. My wife Tracy and I are the owners of the property. She would be here tonight as well, but she's out of town for work. I'll try to very briefly describe the project and then have one request regarding the resolution as it's drafted. The project is to enclose, you can sort of see on that picture, the left side carport to make it into a garage. The footprint would be the same on the front and the side is actually the use permit request is for the side setback, but then the project would go back 5 feet to allow an existing door from the kitchen to open into the garage, whereas right now it doesn't open under the carport. We've gotten letters of support from 4 neighbors, including, because of the way a house is situated, 2 left side neighbors, joining neighbors, 1 right side and 1 across the street. And then, as I think the staff report mentioned, our house is one of 6, or maybe it was our application that mentioned it. Our house is one of 6 that are the exact same footprint, and ours is sort of the last to be updated. Those are my only comments about the project. We request that you grant it. I do have, if you'd like to hear before or after questions, I have one question and comment and kind of request about the resolution as it's drafted.
Okay, any questions of the applicant? Go ahead, sir. What was your question?
Sure. In point 2 of the resolution, it talks about, I think it's kind of after we do the project, how the Board of Zoning Appeals determines that we've done it according to what's granted. And it says that we will provide one or more plats, which may include a wall check plat, may include a final plat, and it's how that's determined by the zoning administrator. I've not been here. I've not been here before. I'm not certain how the Board of Zoning Appeals enforces stuff. My first request would be if there's a way that you can be satisfied that we are adhering to the plans or to what we're granted without us having to go get a new plat. I don't know if that's possible. I don't know if that's common, but we would prefer that. If that's not appropriate or not acceptable, we would prefer that, I guess, the resolution that gets drafted, if you're inclined to accept the resolution, would just include a single plat, or if multiple plats, kind of a defined number of plats, so we know exactly what we have to do for the next time. Thank you.
Arlo, can you comment on that?
Was
resolution on second condition about multiple plats. Just clarifying it for the applicant.
why are so many plats required?
So we require the wall check plat before, at a certain point in the construction process, to make sure that before walls go, before a substantial amount of work is done, that the walls are actually, the foundation of the walls are in the right place. So it's a stop in case there's an issue. And then the final, just to make sure that nothing has changed once it's completed. So it's pretty typical, certainly for BZA requests, but also as part of our plan review process.
Okay.
I think third and fourth plats are only necessary when there's problems. It's typical just to have the two.
Does that clarify for you?
It does. If I may, perhaps my confusion is just the language, since it says it may include, unless it's determined by the zoning administrator. Like I said, I've never been here before. That certainly seems like a perfectly good explanation that actually it's generally not may. It's pretty much you always do a wall check plat and you always do a final plat. So I think my concern would be just the language. Yeah, that certainly clarifies it for me. The only other thing I would add is that we're actually, I believe, putting up the left side wall on an existing wall. We have plans. We've not actually spoken to we've spoken to a couple builders, but we don't have a builder under contract yet. But the builders that we've spoken to have said they think because it's not weight bearing or it's not load bearing, that we can just put the left side wall, and I'm looking up at the picture while I'm talking to you, just put it up on an existing half wall that goes from the front where that left side column is all the way to the back. I'm not certain if that would mean that there's no need for the wall check plat, but that's just my comment on kind of what we're thinking would happen.
Certainly possible. I'm having a hard time visualizing, but.
Okay. I think we need to sort of assume that the process will continue as it always does, and you'll be subject to inspections and whatnot.
You might catch a break, but we have to put the language in case there's, an issue, and that's just standard. So it might not be as bad as you fear, but you'll have to work with staff on trying to limit the number of plats.
It certainly would have to be checked against whatever side setback is approved.
Sure, and so then my only follow-up question, and if this is more appropriate for staff like tomorrow than in this forum, would be, does that mean we have to have two, or does that mean it's still to be determined? And again, if that's more appropriate to talk to staff about it, after you guys decide what you're going to do, then certainly I can call tomorrow.
My guess is the reason the word may is in there and not must or shall is because they can't really tell you that until you get started.
Okay, thank you. Thank you.
Thank you. Okay.
Madam Chair,
Mr. Owen?
are there any speakers?
No.
Madam Chair, on application V-11181-16-UP-1, I move that we adopt the attached resolution granting the subject use permit with conditions.
It's moved by Mr. Owen, seconded by Mr. Melnick. All those in favor?
Aye.
Thank you. Next case, please.
V-11182-16-UP-2 is a use permit request by Jeffrey and Elizabeth Schrad to permit a setback of 12.7 feet from the South Oakland Street right-of-way instead of 21 feet as required regarding a new rear deck. This is in the R27 zoning district on premises known as 3718 First Road South. The staff recommendation is to approve this request.
Thank you. Questions? Hear from the applicant, please.
Good evening. My name is Jeff Schrad, speaking on behalf of myself and my wife Elizabeth, and have no issues with the staff's recommendation. Happy to answer any questions and would appreciate the board's approval. Thank you.
Thank you. Questions for the applicant?
Yes. Perhaps you would anticipate this question based on what you've seen earlier tonight, but have you been in touch with your next-door neighbor?
Yes,
who's
I
the
have.
other half of the duplex?
Yes, David has no issue with it. Also tried to contact the neighbor that I share the back property line with this week. I don't know them very well or at all. I'm not sure we've formally met, but they appear out of town this week. We weren't able to get a hold of them.
Did you, I presume you did not check with the U.S. government who's across the street from you about their opinion on this?
No.
Okay. Did anyone advise you before this hearing that the BZA prefers to have written acknowledgement or comments either for or against from the nearby neighbors?
Yes, Drew Knoxon sent me an email, I forget when it was, last couple weeks. As a suggestion, you may want to get comments from neighbors.
Okay, but it wasn't clear to you that we prefer to get some kind of written signature or anything like that?
I do have the one signature from our direct next door neighbor. I don't have it with me. We went searching for multiple signatures and came up with only one, and I guess I probably should have brought that one, but...
That's the most important one.
Yeah.
So, okay. Thank you. And then I have one other question, which is that you have a right side addition, an addition near the street, for which I guess this property previously came before the BZA to get an approval. Is that right?
It was there when I purchased it in 2008, the exact history of its building and if it was properly...
It looked like it was a little bit still under construction or something this weekend in the back, that the siding wasn't there or something like that.
Oh, that was, I need to replace some damaged siding is all. But that's been there since, I don't know when the previous owner built all that, but no, that was just some damaged siding that I need to go buy some extra siding.
Okay, thank you.
Do we have a speaker?
No.
Thank you. Okay.
Madam Chair?
Mr. Smith.
In the case of V-11182-16-UP2, I move that the Board of Zoning Appeals adopt the attached resolution granting the application subject to the conditions listed in the resolution.
Thank you.
Madam Chair.
Moved by Mr. Smith, seconded by Mr. Melnick. Mr. Owen?
Once again, we have a problem of insufficient documentation about neighbor interest. Here we have a neighbor that's actually the duplex a budding neighbor could not be closer. Here, a mitigating factor, unlike the one that we talked about at such length a few minutes earlier, here the abutting neighbor has a backyard addition of their own, and so it seems like the impact would be less than the obliterated kitchen window view that we had previously. So I'm less worried that the neighbor's going to come back to us furious on this one than I was on the other one. And the other thing is, it's a very obvious improvement to anyone walking down the street or the yard. Commendable that the applicant is trying to improve their property in this particular way, because that door sticking out into the middle of nowhere is not super duper for property values, I'm sure. So I'm less concerned about the prospect of neighbor opposition on this one. And so that's why I wouldn't push for a deferral on this, but I yet another occasion where lack of clarity has disturbed everyone involved.
I agree. All those in favor?
Aye.
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 Thank you. Thank you. Next case, please.
V-11183-16-UP-1 is a use permit request by Aaron Beckles to permit a setback of 13 feet to the eave and 14 feet to the wall and deck from the rear property line instead of 25 feet as required. This is regarding a new one-story rear addition and deck in the R6 zoning district and on premises known as 524 South Larimore Street. The staff recommendation is to approve this request.
Thank you. Questions? Hear from the applicant, please.
Good evening. My name's Aaron Beckles. I'm here with my husband, Jay, and we're here before you this evening to apply to rebuild the current deck that's in the back, and also have a sunroom installed. That's the original deck that was built with the house back in 1986. I heard your comments about the neighbors. I didn't bring a letter, but I was able to pull up on my cell phone an email that I got from a neighbor because he had received his notification, and he sent me the email. He says, got this in the mail, congrats, take it step by step. So that's what
Thank you.
Do you know what the property address is for the neighbor whose email you have?
521
Thank you.
South Larimore Street, Carl Tallis.
So, yes, in theory, the most affected neighbor is the neighbor to your rear, but that's a cemetery, right?
Yes.
So we won't ask you to hold the seance to ask your rear neighbors.
We have a lot of deer back there.
I'm just curious, I know it's been a late hearing, but when I went to visit, there's no markers and there's no monuments that I could see in the cemetery. Do you know anything about?
I think that was evacuated many, many years ago, and it belongs to the neighbor who lives in Fairfax County.
Okay.
That's a Fairfax County property.
So there's no longer people interred there?
No, that was taken care of, my understanding, is a long, long time ago.
Okay. Thank you.
Reynolds Cemetery.
I have Teresa Medina.
My name is Teresa Medina. I am representing the Beckles from the contractor. I'm with Great Day Improvements, who are proposing to install the new deck and sunroom. And I'll be happy to answer any questions you have.
Any questions for the applicant's representative? Okay, thank you. Yes? Yes, you may.
All right. So in case V1118316UP1, I'd like to make a motion that the Board of Zoning Appeals adopt the attached resolution granting the subject use permit.
Second.
On the resolution with the conditions as stated.
Second.
Moved by Mr. Melnick, seconded by Mr. Owen. All those in favor?
Madam Chair.
Oh, sorry. Hold on.
I just have a
Mr.
question.
Owen.
So this property is on the Fairfax-Arlington line, and I'm just wondering, do our practices for my understanding is that the county sends letters to nearby neighbors typically, and so there is a neighbor we just heard who controls what's labeled the cemetery land. Their house is in Fairfax County. Would our normal practice include sending them a letter, even though they don't reside in Arlington County?
Yes.
Okay, so staff believes that that neighbor did receive a letter.
We do. I mean, we can verify. We can produce the list of addresses that they were sent to. I don't have it in front of me, but it's generally the adjacent, all of the adjacent properties.
But we have every reason to expect that that Fairfax County neighbor to the rear did receive a letter. Is that right? Okay. But would you also have posted signage across the county line? Oh, please go ahead.
There was signage posted across the street and all throughout the neighborhood.
My question is specifically, so there's two cul-de-sacs that come at right angles. And so my question is, would the neighbors in the Fairfax cul-de-sac have seen any signs? That's my question to the staff. If you know that there were signs there.
They would see it, but I don't know what happened in the cul-de-sac in the back.
Yes.
I might be able to answer that. When I drove by the Beckles home last week to verify the signage had been put up, the cul-de-sac that, if you're looking at this picture, is to your right, did not have any signage. And per Fairfax County, the owner of the property behind it still had not received their notification as of Friday the 9th.
Okay. Thank you.
We have a motion.
We do.
Okay. All those in favor?
Aye.
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 Thank you. Next case.
V-11184-16-UP-1 is a use permit request by Greg and Mary Moulin to permit a setback of 13.5 feet to the porch eave, 14 feet to the porch base, and 18.2 feet to the second-story eave from the North Oxford Street right-of-way instead of 21 feet as required. This is regarding a new left side porch and a new eave overhang for a new second-story addition above the existing first-floor walls. This is in the R6 zoning district and on premises known as 538 North Oxford Street. The staff recommendation is to approve this request.
Thank you. Questions? Hear from the applicant, please.
Hi, my name's Greg Mullen. My wife Mary is at home with our 2-year-old who has a 103-degree fever, so couldn't be here. So you guys have the plans in front of you. You can see what we're looking to do. I know neighbor recommendations has been a big topic tonight, so there's a 2-page letter that you'll see there that I drafted, introducing our family and the property to our neighbors. We spent a Sunday about a month ago walking around to 7 different neighbors, the 2 directly to our right, the 4 across the street, and the 1 directly behind. We spoke with 4 of them, and 3 of them sent emails with approval for the project. So if you need addresses on those, I can provide those. Last thing I'll say is that unfortunately I'm going to have to come back in October because half of our use permit application was left off the advertisement. So,
oh no.
Yeah. So as much as we've enjoyed being here, that's where we're at.
Seriously?
What half?
This is my architect.
Yeah, the front porch was correct, and the overhang for the front porch, and they advertised the overhang for the second floor, but they didn't advertise the building, which has to be 6 inches. I asked for 6 inches because we're furring out the brick to put siding on. So instead of 20.2 on the front, it's going to be 19.7. And on what I call the back, but is really the side, it's 7 feet from the property line, but we're furring out that as well, so we still have to ask for the 6 inches on the back for 6.5, and the overhang is still going to be a foot. That foot is still within no closer than 5 feet to the property line, no more than 4 feet into the setback. So it still meets the requirements, but because we're non-conforming with the wall itself, we had to ask for that. That didn't make it into the advertisement, so they told us we could not. So I changed the plat that you see now from the original plat that was with the original submission. By the way, my name's Chris Dvorak, and I'm the architect for that. So
Thank you.
that we'll be coming back for to get the final approval on for the backside.
This is extremely irritating. Sorry.
Yes, ma'am.
You know, if it was legal, I would say, we'll just do it.
Could have at least saved you having to wait all night.
Well, yeah. We could have moved you to the front if we had known.
That would have been great.
Well, I mean,
I guess the only
is what it
we
is.
do occasionally maneuver the agenda when there's a valid reason to do so.
The only maybe bright spot is we didn't really address the AC units in this, and by right we can put them on 6th Street side, but we may want to try and squeeze them in the 3 foot that we have, but 3 foot might not be enough in the 8 foot setback portion. The 2 side additions are 8 feet from the side yard, so an AC unit may not fit in 3 feet, we're finding out now, which is what the by right says.
So you can figure that all out between now and 2 weeks from now, or whenever you have to actually know everything.
Yes, I talked with Melissa, and I was going to get the revised,
Amanda.
sorry, and get the revised plat showing the AC and asking for, instead of the by right 5 feet, I guess 4 feet to give us that extra space. But we don't plan out the AC and all the electrical stuff for a use permit hearing, so it's a lot of more work to.
Except when they don't go, when you want to put them where they shouldn't be, and then, of course, you have to do that. You have to at least think about it.
Yeah.
Was the another thing I was curious about? I'm sorry.
No, go ahead.
Recognition.
I'm just exasperated by the issue.
You have a next door neighbor on 6th Street. It looks like this property may have been divided at some point. Did that used to be part of a unified property here? Don't know.
I believe it did. I don't know when it was divided.
Your property has a very unusual shape for the neighborhood.
Yes, sir. It's probably one of the most bizarre.
No, not really. They're more bizarre.
In Ashton Heights?
Really bizarre.
Yeah.
And this is a very significant addition compared to the size of the existing house. And I'm wondering what went into the decision to not just tear and rebuild?
Because if we tear and rebuild, the setbacks of the 25 feet would come into play, and we couldn't ask for a use permit then at that point, and you'd get a house that's 16 foot wide. And we might have to face it out to 6th Street, which really wasn't the best from our perspective view and look.
Mm-hmm.
Okay, thank you.
Okay. So, I assume we're looking, is 1 month sufficient to do all of the county's requirements as well as look at the AC and whatnot?
Yeah, for the October hearing, advertisements will be sent out next week. So if we had the information by Tuesday, it would be sufficient.
And that works for you?
That's not a problem. I've already got it planned out.
Okay.
Maybe they could go early on the agenda next time.
Yes. How about that? How about that? Okay.
Sure. So, I'm sorry.
Mr. Owen.
There was a motion, right? Motion? No, there's no motion. So
There is as soon as you make it.
There's a consensus to defer to October, right? Madam Chair, in the case of V-11184-16-UP-1, I move that the Board of Zoning Appeals defer the matter to the October meeting.
Second.
Moved by Mr. Owen, seconded by Mr. Smith. All those in favor? Aye. I won't see you. I'll see you. Last but not least.
deferral.
Madam Chair, I'd like to make a motion.
Please.
Okay. In case V1118516UP1, I move that the Board of Zoning Appeals adopt the attached resolution to defer the subject use permit to the October 12th, 2016 BZA meeting.
Second.
Moved by Mr. Melnick, seconded by Mr. Smith. All those in favor? Aye. Thank you. We have minutes, please.
I'll make a motion that the minutes for the August, actually, I wasn't here, so.
Okay.
Madam Chair.
Mr. Smith.
I move that the minutes for the August 10, 2016 meeting be adopted as presented.
Second.
Moved by Mr. Smith, seconded by Mr. Owen to approve the August BZA minutes. All those in favor?
Aye.
Aye.
Aye. Actually, sorry, it's late.
Abstain?
I'm abstaining.
So Mr. Melnick abstains.
Yes, Mr. Melnick abstains. Anybody for adjournment? Thank you.
Do you
Yes.
have to take an action? Or
Okay.
Oh, Madam Chair, I
Let the
move
secretary.
that we appoint Amanda Clement, Secretary of the Board of Zoning Appeals.
Second.
Moved by Mr. Smith, seconded by Mr. Owen. All those in favor?
Aye.
Thank you. Welcome. Our sympathies.
You don't get any more money for that.
Yeah, you get what we
You get what we get for that.
which is zippity-doo-dah.
Madam Chair, I move that we adjourn.
Thank you. Second. All those in favor? Aye.
Aye.
All right.
I'm tired.
Okay, you're ready for next time, right?
Yeah. Yeah, when I'm going to need the materials you have,
Ms.
like to
Clement got a
read
little
at the
practice
beginning of the
there at the
meeting.
end.
They'll send you, they can send you an updated one. I can send you one too.
Okay,
So
just
I'll ask
whatever.
staff to send them to you.
Yeah, whatever I need.
Yeah.
So, yeah, so that sounds good.
Okay.